Good morning. This is the Colorado Oil and Gas Conservation Commission Wednesday, April 26th meeting. We will start with the roll call.
Thank you, Mr. Chair. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Oath? Commissioner Messner?
Here.
Commissioner Ray? Commissioner Robbins?
Here.
Mr. Chair, you have 5 out of 7 commissioners present today.
Great. Great to see everybody. That is a quorum, so we are officially able to conduct our business for the day. Generally, we would start with public comment. No one signed up for public comment. We do have one commenter for one of our dockets, and I'll recognize that person later today. We did have one person that provided 2 written public comments. That is Janice Brown, and we've read those written public comments, and we appreciate the opportunity for Ms. Brown to provide written public comments to the commission. With that, we will move to our initial agenda item, which is commissioner comments. Any comments from commissioners for the good of the cause? All right, seeing none, we will move to consent agenda. Does any commissioner have questions with regard to consent agenda? Seeing one question, I would recognize Commissioner McGowan.
Sorry, thank you. And consent agenda includes the OGRIS AOC, correct?
Yes.
Okay. I'm wondering if staff could clarify, when I read the agreements, I see the requirement to pay the penalty, but I didn't see a requirement date to plug the well. And so I was wondering if it still was unplugged and if there's a commitment to get it plugged timely.
Looking to see if anyone from staff or hearing officer might want to visualize themselves to answer Commissioner McGowan's question. I see hearing officer Kirshner is making his way to the floor. Good morning.
Good morning, commissioners. Steve Kirshner, enforcement officer. I negotiated this matter. I can clarify, apologies if it's not appropriately clear from the document itself, but the well has been plugged. The surface plug was set on July 12th. And I believe the cut and cap date is in the AOC as well.
Okay, thank you. Sorry, I missed that.
Yeah, actually, I don't know. Could you repeat your question? I'm having trouble hearing you.
Sorry, I've been having trouble with my mic. I thank you. I missed that in reading the documents, and so I appreciate the clarification.
You're welcome.
All right. Any other questions with regard to consent? Do we have a motion to approve consent?
So moved.
Second.
Motion from Commissioner Cross to approve consent, second from Commissioner McGowan. Any further discussion? Seeing none, all those in favor of consent agenda signify by saying aye. Aye. Any opposed? Motion carries 5-0. Consent agenda is approved. We will now move forward with our next docket 2204-00090. This is a variance request from Wellington Operating Company. I believe we should elevate Ms. Fulcher as attorney for the operator for a short presentation. Oh, actually, before we get to that, we did have one person that signed up for public comment on this variance request. That was Karen Artel. Ms. Amaro, if you could take a look at the folks that are with us, if Ms. Artel is here, if you could elevate her, we would give her 3 minutes for public comment on this variance request.
Okay. I was in the process of being promoted, so I don't know. I missed what you said.
No, you're good. We're happy to have you. You have signed up for public comment on docket 2204-00090. So the floor is yours.
Okay, let me just get to my, okay. So yes, my name's Karen Artel. Thank you for the opportunity to comment. I appreciate the COGCC staff and the operators' efforts over the last year and a half with water testing and reporting and the installation of new water treatment equipment. The addition of radium 226 and 228 and PFAS testing to testing parameters improved the terms and conditions of the permit These substances were found with the required testing. We see from this that we don't find what we don't test for. When the permit was renewed in October 2021, I commented on what I felt was a lack of transparency with the approval process. I was particularly concerned that there wasn't a written report from the Water Quality Control Division regarding the permit application. Though a COGCC groundwater investigation lead did review the variance application materials and provided a technical review summary, there's not an indication that WQCD staff were consulted or provided a written consultation. If I'm reading the technical review summary correctly, I'm glad to see the recommendation that the permit should be revised to require compliance with standards for all parameters listed in the permit at the outfall 001A. Produced water reuse in oil and gas operations saves on fresh water. It's important considering Colorado and the West drought conditions. But apparently there are chemicals in produced water that have no water quality standards or cannot be detected through standard analytic methods. Can the use of treated produced water outside of oil and gas operations be truly safe? I know study in the formation of a produced water consortium is underway to evaluate the use of produced water outside of oil and gas development, but taking into consideration the chemicals used in oil and gas development and the contaminants in produced water, to me, the safe use of produced water and partially treated produced water outside of oil and gas development is questionable, including this discharge to the Box Elder alluvium. Thanks.
Thank you for the public comment. Does any commissioner have questions? All right, we really appreciate your being with us. Thank you very much. All right, Ms. Fulcher, I believe that you are recognized for a presentation.
Thank you very much, Chair, and good morning to you and to the Commission. Give me just a second here. We want to make sure we've got all of our panelists with us, and then I'm going to start my screen. Looks like we've got everybody.
Let's see, I see Mr. Evans and Connor Staley.
That is correct. And then let me start this and make sure that you guys can see. Can you see the slideshow?
Yeah, and it's in presentation mode. So it's
fantastic.
in good shape.
Fantastic. After some early issues with joining as a panelist, it looks like we're up and running. So that's great. All right. Well, good morning again to you, commissioners, to chair, to members of the public. My name is Jill Fulcher, and I'm an attorney with Beatty and Wozniak here today on behalf of Wellington Operating Company in docket number 2204-00090. I'm going to provide you with an overview of the application and then a little bit of an overview of where we're going to head with our presentation before handing it over to our panelists. This is an application for a variance request to order 1253 and an authorization to discharge permit that was issued by the Commission and the Director on October 29th, 2021 for the Wellington Water Treatment Facility. And we're specifically asking that the Commission remove the requirement for an additional monitoring well. That's monitoring well 050G, which is south of a particular rapid infiltration basin as part of that permit requirement and order. I know that some of you were here with us in 2021 when this renewal permit or this discharge permit was renewed for the treatment of produced water for beneficial reuse. So some of this might start out by being a little bit of overview for some of you, but we know that there are members of the public with us that are maybe not as familiar, and maybe some of the commissioners that need an overview. So we're going to start there. But to remind you, first off, this is a water treatment facility that has been in operation since 2006. Again, it's taking produced water from the muddy sandstone unit, treating it, and then discharging it for beneficial reuse to the Box Elder alluvium. And Mr. Evans is going to speak a little bit more on that. That permit was renewed in 2021, and as part of that requirement, the 050G monitoring well was asked to be installed south of the rapid infiltration basin number 3. This application, the variance application, was filed April 28th, 2022, following pre-filing meetings with the commission staff when it had become clear to Wellington that the surface owner on whose parcel that monitoring well would sit was not going to grant access for the installation of that monitoring well. So we knew we needed to do something to address that permit requirement. And so this variance application was filed. This application has been noticed on all interested parties with the input of the secretary on that interested party scope, and also the notice of hearing rather has been published in the local paper. The notice was extended, of course, to Larimer County. Larimer County is the jurisdiction in which this facility sits, and the county has expressed no opposition to the granting of this variance. And I would also note that no petitions were filed against the granting of this variance. The director did provide a recommendation for approval of this variance, along with some red lines to the discharge permit on April 5th, 2023, and we'll speak to some of those points as well. With respect to the presentation today, you're going to hear primarily from Randy Evans, who is the operator in responsible charge of this facility. Again, Mr. Evans is going to walk you through an overview of the facility itself and a little bit more about the monitoring well, and then of course the surface owner's position against installation of the monitoring well. But then Mr. Evans is going to provide you with an overview of the installation of a reverse osmosis system at the treatment facility itself. And we're excited about that because what that reverse osmosis system has done is it's allowed Wellington to meet heightened permit parameters, essentially making the water very, very clean at the facility itself. So at the point of the pipe, before it's ever discharged into these rapid infiltration basins. And so with use of that best in class technology, that's then allowing Wellington to meet the permit standards at a higher point upstream in the operations. So ensuring compliance at a point further upstream than where it would have with that monitoring well G. So I think it's because of that, and we saw this in the director's recommendation, that staff feels that this variance is protective of public health, safety, welfare through the installation and operation of that RO system. So Randy's going to talk about that. And then you're going to hear from Paul Stone, who has done some additional work on the empirical data and other studies and reports to demonstrate that from his findings, the groundwater here in this box elder alluvium is moving south-southeast. You're going to see some maps of the groundwater flow here. And why that's important is it means that the groundwater, or the water, excuse me, that's being discharged into this aquifer is staying on the same property, essentially, of the surface owner that does not want the monitoring well, is not moving to adjacent owner properties. So again, adding a further protection point. So that's our overview. I'll walk us through some summaries at the end, and then we're here for your questions. So with that, I'm going to introduce Randy Evans, and he'll provide you with a little bit of his background and walk you through our slides.
Great, thank you.
Good morning, commissioners. My name is Randy Evans, and I am certified by the state of Colorado as a Class A operator for industrial wastewater treatment, and am the operator in responsible charge for the Wellington operating company, Wellington Produced Water Treatment Facility. The facility is located approximately 5 miles northwest of Wellington, Colorado, and has been in continuous operation since April 2006, treating produced water only from the Wellington Muddy Sandstone Unit. The facility currently receives produced water from 11 active producing wells from the Wellington Muddy Sandstone Unit, and which is delivered to the South Battery for pretreatment and treatment. To date, the facility has treated and discharged approximately 191 million gallons of water through the rapid infiltration basins to the box elder alluvial aquifer. And in the 17 years of operation, Wellington Operating Company has never received or been issued an enforcement action or notice. Next slide, please.
Hey, Randy, real quick, before I move to the next slide, if you're able to go video on, I just wanted to remind you that I don't think your video is fully on. If you're able to do that, that would be great.
It's not shown. I'm not finding where to turn it on.
If not, that's okay. We can hear you okay, which is the more
Okay.
important critical element.
Okay, that's fine with me. I'm sorry about that. Okay, the permit was issued October 29th, 2021 and expires October 28th in 2026. The current discharge permit added additional monitoring parameters and specific discharge limits for certain parameters, which previously had been as a report only or not specifically monitored. Those changes amount to the addition of the monitoring well outfalls 050G, which we're discussing today, and added ag limits to outfalls 050B for chloride, barium, boron, radium 226, 228, and 2 additional volatile organics. It also added limits for barium, boron, radium, and 2 additional VOCs at outfall 001A, which is the outfall at the treatment facility. Let's see, next slide, please. This, this slide is an overview of where the different facilities are located. The Wellington Produced Water Treatment Facility is located on the South Battery, and we have our treatment facility within the building there with our outfall 001A as a last point of discharge. The water transfers from the outfall 001A by pipeline down to the 3 RIBs represented along County Road 70 as the blue pins. 2 are on the north side of the road and 1 is on the south side of the road. This also indicates where our monitoring well that is being used is located. Monitoring well 050B, which has been there since the initiation of the project, and then the proposed monitoring well 050G. Wellington Operating Company does not have an oil and gas lease covering the surface lands with Seaworth Farms, so we have no express right or implied right to locate a monitoring well without the Seaworth's consent and permission. There's a limited surface use agreement with Seaworth Farms that allows us access to the existing monitoring wells and the rapid infiltration basins. Next slide, please. Oh, I think you went one too far. Seaworth Farms and the principals, Richard and Troy Seaworth, were notified when the groundwater study was completed by Stonegate Land and Water in April of 2021 in preparation for the permit application. A copy was supplied to them by email, and Wellington Operating Company called their attention to the fact that there was a recommendation for the additional monitoring well to be installed, and they never responded to additional inquiries about this recommendation. Next slide, please. After the discharge permit was renewed, I contacted the surface owner, Richard Seaworth, about locating the monitoring well 50G, and met with Richard during the week following the permit issue. We staked the location, and then negotiations were conducted between Richard Seaworth and Seaworth Farms and a representative of Wellington Operating Company, Tom Shaw, who is no longer with the organization. Those negotiations were reported by Tom as falling through as they tried to progress. In the event that the monitoring well would have been allowed, I contacted a geologist and a drilling company about scheduling the well to be installed prior to April 2022. I I started that as early as in February. Once we determined that the monitoring well was not going to be allowed, I canceled the drilling operation in mid-April. Next slide, please. We have installed a reverse osmosis system. Now, this is a picture of the control panel and the skid that has that. The reverse osmosis uses a partially permeable membrane filter elements and elevated pressures to remove contamination from the wastewater being processed. The membranes do not have specific pore sizes like most filters that people are familiar with. A high pressure on one side and low pressure on the discharge side, along with the semi-permeable membranes, result in water being able to pass through, and various contaminants are rejected and turned back by the membranes. Reject water, which is also known as brine, is carried away as a percentage of the water that goes into the treatment unit. We're rejecting approximately 20% of the water that goes into it. That water is currently being injected in the on-site injection wells. Next slide, please. After performing numerous bench tests on the water in October and November of 2021, Wellington Operating determined that the RO system would be required to meet the permitted discharge limits at both outfall, well, at outfall 001A at that time. We, at that time, contacted various RO system suppliers about pricing and availability for a unit to meet the needs and timeline for the facility to have a system online by April 28th, 2022. Purchase orders for the RO skid and additional support equipment were placed in late December and early January of 2022. In addition to the RO skid, the purchase orders included new control system, pumps, tanks, pipe and fittings, etc., to support the system installation. The skid was received on October 6th of 2022, but because of the supply chain issues at that time, it did not come with the main process pump, which was received in May, on May 6th of 2022. After installing the pump and completing some of the hookups, we were getting near the end of May, so a decision was made to not start processing water through the facility until June 1st of 2022. There were additional startup issues that in commissioning that included coordination of 2 new control panels, one for the main facility and the one on the RO system. And then both control panels are set up to provide alarms should various conditions that are monitored result in a condition that would require alarm and attention to the system. Next slide, please. Okay, once the facility was brought online for continuous operation, operating Monday through Friday, which was in late September of 2022, it was determined that the boron limit at outfall 050B was not going to be met with the RO membranes that were currently in use, and we investigated and purchased new membranes to go in that would reject boron at a higher rate. The new membranes were received and installed in November, and then we started doing additional testing to determine the boron removal rate with the new membranes, which was improved. But we found that we needed to additionally treat the water to be able to get the cleanliness of the water or quality of the water that we needed to meet the ag limit of 0.75 parts per million at outfall 050B, which is within the permit. Next slide, please. Changes in the pretreatment pH were made slowly so that we were able to maintain compliance at outfall 001A with water leaving the building. And the only additional parameter that was of concern was the boron, which does not have a drinking water standard, but does have an ag standard of 0.050 or 0.75 parts per million. To meet this boron limit, we were required to raise the pH to change the charge of the raise the pH of the water to change the charge of the boron, and then the RO system was able to reject it. We've been analyzing samples at outfall 001A twice a month to track the changes, and there's been an additional 28 samples collected off the RO sample port to determine the optimum pH for the boron removal. And right now, outfall 001A is at the water treatment plant, and we're working to and have been able to develop a process to meet the ag standard for water at outfall 001A that is required at outfall the monitoring well 050B. So we're discharging water currently that meets the requirements at 050B. And at this time, I'll turn it over to Mr. Paul Stone. And thank you very much.
And thank you very much, Mr. Evans. And for the commission, it looks like we're having a little bit of trouble getting Mr. Stone elevated as a panelist. So I think what we can do is I will move forward with the presentation and just summarizing some of the evidence and keep us moving. And then if he's able to join, I can walk us back to this point in the presentation. I would note that Mr. Stone's testimony today is a summary of what he's already provided in the written record. So in case he somehow cannot join us, this information was part of his written report, which essentially helps demonstrate that. And I'm going to move over to this slide. This is the groundwater flow direction, that groundwater is flowing south-southeast based on various data points and evidence that he's reviewed, which means that groundwater that's being discharged, or the water that's being discharged, is staying within seaworth properties. So I'll see if he can join. If I'll keep an eye out for Mr. Stone, but otherwise keep us rolling. So my remarks in closing here, and I want to thank you all for your time. I want to just bring us back to Rule 502 and the elements that have to be present for this commission to grant an application requesting a variance. I know you've been through many of these hearings before, so this gets a little repetitive, but I want to just draw your attention back to some of what you've heard today in this presentation, but also as part of the written record. The first being that the applicant is unable to comply with an order or permit condition or rule, and has made a good faith effort to comply. So here you heard testimony from Mr. Evans, and we put this into the record as well, that conversations were being had with the surface owner regarding the location of this monitoring well, even prior to the renewal permit hearing back in 2021. During those conversations, it was not foreseeable to Wellington that Mr. Seaworth was going to take issue with the locating of this monitoring well. Otherwise, that would have probably been an item of discussion during our hearing back in 2021. It wasn't until just days later when those conversations were had to get the written consent required for this monitoring well that it became known to Wellington that the surface owner actually did have issues with the location of this monitoring well that spanned the gamut. And after about 3 months of ongoing meetings, phone calls, on sites, it became clear to the surface owner, no amount of money, nothing we could do was going to allow the surface owner or would result in access from the surface owner. So good faith effort was made, but unfortunately, because these particular lands are not governed by an oil and gas lease or any other right that would allow Wellington to put this monitoring well on site, it's all governed by the surface use agreement. Without that consent from the surface owner, Wellington does not have a legal right to put this monitoring well on site. So moving to the next element, that the variance does not violate the basic intent of the act. Granting this variance will allow this continued use of this water treatment facility, which not only serves the purpose of allowing effective production from the muddy sandstone unit, but then allows a place for that produced water to go to being treated and then discharged for beneficial reuse, which, as I know, a goal of this commission, and I know as a state we're moving more and more towards beneficial reuse and recycling programs. That is what this discharge permit does and what the variance will continue to allow. With respect to the monitoring well itself, primary reason for the monitoring well G was to add an additional compliance point south of the rapid infiltration basins. But again, now with the installation and successful operation of the reverse osmosis system, which Mr. Evans described, we can meet those permit parameters at a point in compliance upstream of the discharge point. And that's what the director is recommending be changed as part of the permit. So we're ensuring that the act is protected or that the act is being met in protecting public health, safety, welfare, and the environment. With respect to the next element, the variance is necessary to avoid undue hardship. Without the ability to continue to use this treatment facility, Wellington will likely have to shut in or even prematurely plug a number of very productive wells that are still within active life. We're not in an end of life with these wells because there will be a problem with the throughput for what we do with produced water. So that, of course, results in a hardship to Wellington, but also to its royalty owners that are enjoying right now the benefits of those proceeds from productive wells. This also then has a cascading effect on the aquifer itself. Right now, the surface owner is enjoying the additional discharged treated water into a depleting aquifer, and that will be cut as well, or could be cut as well if the variance is denied. Final element, again, this kind of works back to why this variance is in keeping with the act. This variance also will not result in any adverse impacts to public health, safety, welfare, the environment, or wildlife resources. Again, the monitoring well G was put into place as another point of compliance and also to provide historical discharge data. I've mentioned what the RO system does a few times for ensuring that we've got very, very clean water to ag specs before the water even goes into the ground and being discharged into the RIBs. So we're ensuring protection there. With respect to historical data, of course, if Wellington was able to put the monitoring well in place, I think they would. That would be the simpler course here. But with respect to Paul Stone's evidence, we know that the groundwater flow is moving south-southeast, which means that all discharge, whether it's future or historical, is staying essentially within that Seaworth Farms property, which is a very, very large area of land. And that's the surface owner that does not want the monitoring well. The adjacent owners to the west in particular are not seeing groundwater movement. And we know that from about 17 years worth of empirical data. So that further ensures that protections to adjacent owners are being met. And that was noted in the director's recommendation as part of staff's technical review. So with that, I'll just close by saying that we appreciate your time. We appreciate you bearing with us on some technical difficulties today. We appreciate the staff's time with this application. especially Rick Allison and Mimi Larson. Ms. Larson's always, a helpful resource in filing variance applications from the procedural side. And then, of course, Mr. Allison is the technical expert on this, and we really appreciate his time as well. I know that he and Mr. Evans work closely in the field. A lot of regular inspections and on-sites happening between the two of them. So with that, we are available for questions. If Mr. Stone is able to join, if you do have a question for him, I hope we're able to elevate him, but for now, we'll just continue to kind of troubleshoot that on our end. But that concludes our presentation. Thank you.
Great. Thank you. And thanks for stopping the screen share so we can see everybody. At this time, commissioners, we turn it to ourselves for questions to the applicant. Commissioner Messner.
Thank you, Mr. Chair, and thank you for the presentation and the application. I just to clarify, you're willing to adopt the full red lines that are being proposed by staff. I mean, I knew that you said some, but it's all of them, everything in the director's recommendation.
Thank you for that question, Commissioner Messner. Yes, we are appreciative of staff's red lines, and we will adhere to those red lines if adopted by the commission in full.
Okay, thank you.
Good question. Further questions? I see we have Mr. Allison with us if we have questions with him as well. Commissioner McGowan?
Thank you, Mr. Chair. So per Ms. Artel's testimony, does staff have any comments about collaboration with the water quality control division over at CDPHE? I don't have any issues with this. Reverse osmosis is a pretty high-tech way to get rid of contaminants in the water. And so I think the operator's done some good work to figure out how to treat the water ahead of time before, at the outfall, which is appreciated. I'm just wondering if staff has any feedback about, I mean, our rules align with water quality, but I just want to make sure that we're addressing Ms. Artel's concern or comment.
Mr. Allison?
Good morning. Thank you, Chair Robbins. Rick Allison, Environmental Protection Specialist and Groundwater Investigation Lead in the Environmental Unit at the COGCC. Commissioner McGowan, to the question about collaboration with Water Quality Control Division, we did reach out when we received the variance request, discuss this with WQCD staff, and basically when we put forward the proposal that to issue this variance, they would have to comply with all Reg 41 parameters at end of pipe. WQCD agreed and offered no formal consult beyond that.
Thank you.
My pleasure.
Further questions? Seeing no further questions, do we have a motion?
I'll move approval of the variance application with the understanding that it would include the red lines that are proposed in the director's recommendation.
Second.
Motion from Commissioner Messner to approve with red lines, second from Commissioner Cross. Is there further discussion?
Mr. Chair.
Yes.
I would like to thank the applicant for the variance application and their willingness to work with staff. I think this is a good example of why the variance process is in place. Ms. Fulcher, I appreciate that you did go through and make a showing on all the different elements that are required as far as being able to ask for a variance, which does not always happen when people are asking for variances in front of us. And so I do appreciate that. That is important, and that is a requirement that we actually are able to make a showing on all of those elements within the variance rules. And so I think you've done a nice job with that. I appreciate the staff's red lines and being able to find, I think, a solution that in many ways is more protective to public health, safety, welfare of the environment, and wildlife resources than the initial monitoring well may have done. So thank you for that.
Appreciate the comment. Any further comments? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you very much, Ms. Fulcher, for you and your client's presentation.
Thank you very much, Commissioner.
Commissioners, I think at this point, let's take about a 14-minute break, get the next OGDP set up for hearing. Let's return at 10 a.m. All right, we are back live. Good to see everybody. We're going to take up docket 2209-00240, an oil and gas development plan for PDC Energy. We will start with recognizing Jason Maxey, the director of the local government and local government designee from Weld County. Good morning, Jason. Good to see you. If you would like, the floor is yours.
Thank you very much, and good morning, Chair Robbins and fellow commissioners. Appreciate the time as always and the opportunity to speak for a couple minutes regarding the docket item in front of you today, as well as the Weld County process that has led us up to this point and the steps that we have already gone over here at the local level regarding PDC's Whitney Oil and Gas Development Plan. Just a few high-level dates for you all regarding how we got to this point. First off, you all should have 2A comments that Weld County submitted to the COGCC back in February 28th to be exact of this year. And those are included in the director's recommendation as normal. Going back a little over a year ago, though, we started the process January 14th, 2022, with a pre-application meeting. And attendees, for the record, included PDC staff as well as Weld County staff, obviously. We did have City of Greeley representatives on the line, as well as staff from the COGCC and the CPW. We received the application from PDC a little bit later that year on August 4th. We did not, through our process, receive any public comments. We did not receive any applications to be a part of our hearing for this location, and we did not receive any negative types of comments or concerns regarding the application. We held our hearing on December 15th, and it was approved by the Weld County Hearing Officer, and that final order was recorded with the clerk and recorder and noticed in the Greeley Tribune as per our code requires on January 4th of 2023. Now, a few specific points about this location. The location, when we went through it and when we worked with PDC, it is sited within a mapped bald eagle winter night roost. For our application, CPW's referral comments and timing stipulations were heavily discussed during this 1041 hearing and were made a part of our record. The wildlife resource consideration section of the director's recommendation that we received and that is provided to you all first indicates that CPW has granted a waiver as the roost has been determined inactive, but later on in that section states that additional surveys will be conducted prior to construction and that PDC will consult with the CPW to determine if the timing stipulations are even necessary. And I just bring that up because, again, we had a robust discussion about this exact same topic during the 1041 hearing, and I'm sure this will be a big part of PDC's presentation to you all today. But I did just want to bring up that pursuant to the 1041 WOGLA hearing officer's final order, we do have an item, which is numbered 4.1 in our hearing final order, that if PDC plans to perform construction activity between November 15th and March 15th, then PDC must provide evidence that CPW has granted a waiver to that roosting season. And they can just provide that via our sundry process, and which PDC is well aware of. So we just wanted to call that out, that we noticed that in the director recommendation, and just bring that up for your consideration and knowledge as well, that we have that stipulation in there regarding CPW. From a land use perspective, Weld County does appreciate PDC's effort to consolidate oil and gas operations to an existing disturbance area. As I'm sure they'll go into, the siting for this proposed location is on an existing pad that has had multiple occupations for oil and gas development. In our opinion, from Weld County, it's in a little bit of a challenging area due to development, but we do believe that based on the land use surrounding this location, based on the land usage and municipal boundaries around the entire development area, that the reoccupation of this location is the highest and best use of the land, and that it also fits in with cumulative impacts as well as compatibility from a local jurisdiction standpoint. So with all that being said, again, I appreciate the time as always. It's been a little bit since I've been in front of you all. So thank you for the time, and we would support approval of this permit at the COGCC level. And as always, happy to answer any questions that the commission might have. Thank you.
Thank you, Mr. Maxey. Appreciate your presenting to us. We do value the relevant local government's opinion with regard to OGDPs. And so we appreciate Weld County and yourself taking time to provide us the work that you've done on this, as well as your support for the project. That's an important element, and that's why we lead off with Weld County and yourself. Do commissioners have any questions of Mr. Maxey? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Maxey, for being here, providing comment. And I did have an opportunity to read through the WOGLA process on this particular application. Wanted to ask you a few questions. So first, I wonder if you could just talk to me about what the near urban zoning is in Weld County, and how that, what type of things would one see in a near urban environment, or siting considerations within that near urban environment, particularly in reference to an adjacent or one of the property owners within that was within the ALA was considering utilizing their property for commercial development in the near future, it sounded like. And then what other types of allowable land uses are in this near urban designation, I guess.
Thank you very much, Commissioner Messner, excuse me, tongue-tied this morning. So Weld County, when we look at oil and gas development, we have two things that we look at. Number one, obviously, there is still the underlying zone districts, as you all, I'm sure, are very familiar with a variety of counties and municipalities around the state. We have ag zone districts. Weld County does have some residential zone districts, commercial, industrial, etc. And there are certain uses that are allowed within those zoning districts. Oil and gas development for upstream well pads, in this case, they are allowed in any zone district as long as the operator gets an approved WOGLA through our department and our process. Now, when we were looking at developing our code over the past few years, almost 4 years now, we've been in existence, as you all know. Over 90%, I think it's close to 95% of Weld County is zoned agriculture. And so we did not want all of the agricultural zoned areas to make it seem like they were far away from development that might be coming down the path from municipalities or from some of these areas that were a little bit more of a growth potential. So when we were developing how we wanted oil and gas to be viewed, and how we wanted the operators to take additional considerations for their permits, we decided to not just look at it from a zoning perspective, but we created two different planning areas within Weld County. One of them is the near urban, as you mentioned. The other is the ag rural. The way we developed the near urban planning area is based on the potential for growth. And so we have coordinated planning agreements with many municipalities in Weld County. We have 32, I believe, municipalities in Weld County, and I think we have 19 or 20 agreements with them. Regardless of those agreements, what we did is we took the ever-changing annexed boundaries of a municipality, and we said anything within 1 mile of that boundary is potential for high growth, meaning it could be residential, it could be commercial, etc. But those are going to be the primary areas that a municipality may look to annex and bring into their municipal boundary. So 1 mile from a city limit is included in the near urban area. Now, additionally to that, what else could precipitate growth? That is the development of services, specifically water. So we also have any area that is served by a public water district, whether that is a municipality or we have certain other water districts like North Weld or Central Weld water districts that serve areas. Any area that is served by a water district beyond that 1 mile from a municipality is also within the near urban planning area. And again, it was to take a look at the areas that had higher potential for growth compared to the further out areas in Weld County. Both of them could be ag zoned still. You could have a near urban area that's ag zoned. And regardless of that, again, we wanted to have a little bit additional considerations for noise, for lighting, for traffic that happen and that are reviewed under that near urban area versus the ag rural area.
Super helpful. Thank you for that answer. A couple other questions. In the WOGLA permit, it indicates that PDC will be required to retrofit existing facility. I'm paraphrasing here, but existing facilities to be tankless. I guess, what does that mean to you?
I'd have to find the exact part in the order, but what that in general means to me is when we have a application such as this to where the operator is doing, looking at cumulative impacts, reoccupying a location that has existing infrastructure already on location. We talk to them about what additional changes are they doing to the remainder of the facility that's older, that's already there. What are they doing and planning to do for that would help with the discussion about, is this the best location? And so when we talk about reoccupation, and in this case here, we do have an older WOGLA on location as well. So we've seen this kind of grow over the years with a existing location that has an older permit and now a new 1041 on top of it. We include the older permit within the newer standards as well for the 1041. And so we ask, what are the options for lessening the amount of tanks on site to have oil and possibly produced water takeaway that would lessen the impacts when you are bringing more development to that one location? Because even though cumulative impacts from our viewpoint is a good thing to look at, and consolidation is a good thing to look at instead of new surface disturbance, we also have to acknowledge that when there's more development on a location, inherently it's obviously a bigger location. How can we lessen some of those impacts of a bigger location? And so trying to get hydrocarbon takeaway via pipeline is one of those ways that we seem to lessen those impacts by having less tanks on site.
Okay, thank you. Last question, and this will be about road agreements. And I understand that there's, there was some discussion with Weld County as far as transport routes and stuff, but I believe through your process, you also have consultation with proximate local governments or local governments that may also be impacted by haul routes. And but it wasn't clear to me, but did Greeley enter into, and I'll ask the applicant this as well, obviously, but I guess I was curious, the conversations within the WOGLA process between Greeley and the haul routes that were anticipated to go either through Greeley or near Greeley, and any kind of road use agreements that were associated with those particular discussions within the WOGLA process.
Yeah, thank you for that, Commissioner. So I was pulling up the City of Greeley's referral that they sent back, which is obviously included in our permitting review, and is obviously also given to the operators. Whenever we receive referral comments back, we don't just keep those, we give every referral comment to the operator so that they can hopefully incorporate some of the items of advice or concern from those referral entities. So in this case here, the city of Greeley gave a very in-depth referral back to us during that referral period, some of which was from their community development and engineering group. And there is a specific item in here that says, the city of Greeley is requesting to enter into a roadway maintenance agreement to ensure maintenance of roads utilized to access the location. Now, the actual access point is on Weld County maintained roadways. Again, it is existing. It was approved through Weld County. We do have the normal Weld County agreements in place for road maintenance and that PDC has entered into. However, as you alluded to, there is City of Greeley annexed areas to the west of this location, as well as a little bit further to the south of this location. So they would be on county roadways for a little while until they entered onto City of Greeley roadways potentially. And so that comment was received, and I do believe PDC could definitively answer this as well. But we definitely take that in consideration as far as our relationship with our nearby partners. We also have a comment on here that certain right-of-way permits would be required from the city of Greeley if improvements are going to happen within the public right-of-way or public easements. So those items were fully considered. PDC has them, and they could speak into more detail as far as if they've started down that process with a road improvements agreement with Greeley, and they could answer that for you for certain.
Great. Thank you, Mr. Maxey, for answering my questions.
Thank you.
Good questions. Others with questions for Mr. Maxey? And good answers too, by the way, Mr. Maxey. All right.
Thank you very much.
Yeah, thank you. I know how to reach you if questions come up again, Mr. Maxey. If you want to go about your day, we can let you do that. And if something comes up, I'll get in touch and bring you back to the panel.
Perfect. That sounds good. Just in case, I do know that one of my teammates, Kelly Holiday, who actually was the specialist for our team on this project, she's listening in as well. And so if by chance there's something, she could fully answer the question also if it might take me a few minutes to rejoin. But you either reach out to me or Miss Holiday could be queued up as well.
That sounds great. Thanks.
Thank you.
All right. At this point, I believe we're going to recognize Mr. Pisharla as well as his panel for a presentation from PDC.
Great. Thank you and good morning, Mr. Chair, Commissioners, Director Murphy and staff. And I'd also like to thank Mr. Maxey for his comments and support of PDC's application. My name is Joe Pershala with Wellborn Sullivan Meccan-Tooley. I represent PDC Energy, and I'm pleased to present the Whitney Oil and Gas Development Plan here today. This development plan is a culmination of extensive planning and cooperative work with all stakeholders, including Weld County, the City of Greeley, surface owners, nearby residents, and commission staff. What will be presented to you today is a model of coordinated site consolidation to minimize surface disturbance, reduce emissions and impacts, while providing the opportunity to maximize mineral acreage development. Presenting for PDC here today are Vanessa Chase, the regulatory manager, Brian DeRose, surface land manager, Brian Cochier, manager of operational compliance and policy, and Meredith Knauf, air quality policy advisor. We also have available for questions Zach Leisenfeld, a EHS professional, and Daniel McCoy, the land supervisor. PDC's application requests that the commission approve an oil and gas development plan that covers approximately 1,006 acres within townships 5 and 6 north, range 66 west in Weld County, Colorado. At the heart of this application is a request to modify an approved and active oil and gas location that would be renamed as the COGCC K2 Whitney pad. It's located outside of the mineral development area to the northeast. This pad is currently approved for 38 horizontal wells, which are permitted to develop 3 prior approved drilling and spacing units. Now, consistent with Rule 603D and E, PDC has designed a development plan that will consolidate 16 new horizontal wells on this existing pad. In order to do so, PDC seeks approval today to disturb an additional 1.71 acres within the overall existing pad footprint to accommodate these additional 16 wells. Those additional wells will develop what is a proposed 972 acre drilling and spacing unit that is located southwest of the location to produce oil and gas from the Niobrara, Fort Hays, Codell, and Carlisle formations. As you'll see, the expansion of the pad is actually contained within the original U-shaped footprint of the original pad design, such that the working pad surface will not be expanded closer to any of the residential building units or other receptors near this original pad. With respect to ownership, PDC owns leasehold covering more than 45% of the mineral interest in the unit and therefore has the right to develop. The location itself is on agricultural fee surface. The working pad surface of the location is within 2,000 feet of one or more residential building units, which is the only Rule 304 B2B criteria met by this location. Therefore, PDC has prepared an alternative location analysis that concludes, after considering all receptors and technically feasible alternative locations, that modifying this existing pad will best allow for development of the proposed spacing unit, and provide the greatest opportunity to avoid and minimize impacts to public health, safety, welfare, the environment, and wildlife resources. Importantly, this proposed modification of the pad will enable PDC to utilize its full suite of best management practices, including retrofitting the pad to a tankless facility, electrification of all production equipment, and to conduct a single and final reoccupation of this pad to drill and complete all the previously permitted and newly permitted wells at this location. At the conclusion of that occupation, the pad will be placed on production and interim reclamation performed. And now, as you've heard from Mr. Maxey, Weld County is the relevant local government, which approved the modification of this location through the WOGLA process. City of Greeley is the only proximate local government. It has been provided notice and has not objected to this application. PDC has given proper notice pursuant to Rules 504A and 303E1, and no petitions or interventions were received. On April 12th, 2023, the director issued a director recommendation, which has recommended that the commission approve the Whitney OGDP. Thus, we maintain that the application satisfies the Conservation Act and commission rules, and importantly, captures the spirit of the mission change rules to consolidate new wells and locations, and where possible to do so using an existing location to best protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. PDC respectfully requests that the commission adopt the director's recommendation and approve the application. Thank you for your time, and I would like to pass the baton to Ms. Chase, who will begin PDC's presentation.
Good morning, Commissioners. I'm Vanessa Chase, Regulatory Manager for PDC. We'll be kicking off this presentation with an overview of the Whitney OGDP. The Whitney OGDP entails amending an existing location that was initially designed in 2017 and approved in 2018. The existing producing Sealy wells were drilled in 2019. Internal conversations kicked off in January of 2022 to redesign the location to include additional wells. A pre-application meeting was held with Weld County in January of 2022, and then subsequently an OGDP submittal in September of 2022 with a WOGLA approval in December of 2022. The OGDP passed completeness 4 months after submittal, and we received director recommendation for approval in April of 2023. This existing location is located within Weld County, with City of Greeley as a proximate local government. We have an approved WOGLA, and Greeley has expressed no concerns for this amendment. There are no schools, childcare centers, water supply areas, or disproportionately impacted communities within a mile, and there are no impacts to floodplains or wetlands. The aerial photo on this slide shows the existing approved location. The surface disturbance increase to add the additional 16 wells is 1.71 acres. There will be 4 wells plugged and reclaimed as a result of the Whitney Well Development Area, which will return 4.8 acres back to the community. This results in a net benefit of a little over 3 acres given back to the community. With adding the additional wells, PDC is committing to decreasing the current pad emissions through facility BMPs, such as electrification and retrofitting to a tankless hydrocarbon storage facility, which you will have more details later in the presentation. As the planning for the development of the Whitney wells kicked off after the mission change rulemaking, PDC designed this well pad in accordance with Rule 603D and 603E, where well consolidation and development from existing oil and gas locations is encouraged. The photo on this slide shows the current location. The area around the Sealy wells that are now producing has been through interim reclamation. The red box to the east of the production facility area and to the north of the existing surface cased Chalk and K2 wells illustrates the additional 1.71 acres that will be added to this well pad where the Whitney wells will be placed. The Whitney OGDP proposal entails adding 16 wells to an existing location that currently contains 26 producing wells, 6 2.5-mile wells, 5 4-mile wells, and 1 1.25-mile well that all has had surface casing set. This pad would ultimately contain 54 wells and develop a total of 4,448.74 mineral acres from one single surface location. PDC has stretched the limits of step outs and wellbore distances on this location due to the mineral acreage being under the city of Greeley, which would be otherwise hard to reach without creating substantial impact to sensitive receptors due to the dense development. Construction is planned to start on this location in the third quarter of 2023. The drilling of the existing surface set wells, the new Whitney wells, and completion operations would immediately follow. When planning our operations, PDC thoroughly evaluates overall impacts to all sensitive receptors surrounding our locations to ensure the least impactful schedule as possible. This particular development schedule was planned to acknowledge that we will be returning to this location to finish drilling the existing surface set wells and to be able to incorporate the Whitney wells from this proposal. Being mindful of the surrounding residents, we are committing to one last single occupation on this well pad to drill all wells and conduct completion operations sequentially. As you can see on the map shown on the right, the development from this Whitney OGDP is surrounded by existing horizontal wells, making it the last development to occur in this area by PDC. I will now turn the presentation over to Brian DeRose, PDC's Surface Land Manager, to detail the extensive alternative location analysis that was conducted.
Thanks, Vanessa. Let me kick off this portion of the presentation with a little history of the area as it relates to alternate locations, how PDC evaluates alternate locations, and roll into specifically how we arrived at the Whitney location as the preferred site. The evolution of the Whitney location has taken a unique path over the course of several years. This pad was originally planned as the Ostman pad dating back to 2017 with SRC Energy, which is identified as alternate location 2 on the right-hand side of your screen. It had relooked and retooled in 2020 under the SB 181 lens as the Whitney pad. I'll dive a little deeper into that later on in this presentation, but before I get into the specific ALAs, I'd like to highlight how PDC addresses the site selection and alternate location analysis from a 50,000-foot view. While the ALA process is not necessarily a new process to PDC, and one that we've always utilized in some form or fashion during our site selection analysis, it is something that we took a deeper dive into after the new local and state rulemakings in 2020. These new rulemakings provided PDC and really the industry as a whole with a new perspective on how we responsibly develop minerals in the DJ Basin. So what kind of impacts does PDC consider when we are conducting our site selection or ALA process? Our considerations include, but are not limited to, proximity to building units, operational feasibility. Does this location meet the standards of our site-by-site risk assessment for development? Impact of future land use. Will this site have a negative impacts on future development, or are there pending development plans in the area? If this site is being planned on lands that are intended for long-term farming operations, will the surface owner or the tenant farmer be negatively impacted by the site for these future operations? Proximity to cultural features. Are environmental concerns such as wildlife corridors, raptor eagle nests, prairie dogs, burrowing owls, wetlands, floodplains, designated surface water, and much more. Access to location. Does PDC believe we can construct or utilize an existing access that is safe with minimal impacts, not only to surface owner, but the surrounding community as well? Surface owner negotiations. PDC wants to be a partner with our landowner, our stakeholders, and these proposed locations have to be locations that not only work for PDC, but for the surface owner as well. Geology. Does the subsurface structure formations complement the surface location in which to safely and adequately develop hydrocarbons? Last but not least, consolidation. Can we utilize any nearby oil and gas sites that yield minimization to the surface areas and already in place infrastructure? You'll see as we march through this presentation, consolidation was in large part the biggest contributing factor to the alternate location analysis. Based on Weld County's pre-application meeting held in January 2022, PDC, Weld County, COGCC, CPW, and City of Greeley discussed 3 alternate locations. The first alternate location considered was a location just south of the existing PDC trout pad that offers opportunities of consolidation and just 3 RBUs within 2,000 feet. However, it is located in a pivot irrigated field that offers an access that would route just adjacent to a nearby RBU. It is located outside of high priority habitat, wetlands, and floodplain. All signs pointed to a feasible location, but PDC was unsuccessful on several attempts with the owner to obtain a surface use agreement and advance any negotiations. The owner owns a total of 160 acres at this parcel, as well as additional property south of O Street. She was not amenable to a site anywhere located on her property. Next slide, please. I know I'm jumping around here, but in the essence of cadence, I'd like to move over to alternate location 3. Alternate location 3 from the ground appeared to be a palatable location. However, after discussing with the surface owner and taking into account the residential building unit owners within 2,000 feet, PDC moved away from this location as being feasible based on the opportunities the Whitney location provided versus alternate 3. 24 RBUs within 2,000 feet and a haul route in order to get to this location. PDC viewed this as cause for a larger disruption to the surrounding community than the proposed Whitney location. Now let me jump back over to alternate location 2, as I was alluding to earlier on in this presentation. This was the original Oastman pad. This is really where the evolution of the proposed Whitney location came about. PDC has a surface use agreement at this location and has received a use by special review permit from the City of Greeley on July 14th, 2020. Additionally, PDC received 5 of 5 acknowledgements from the RBUs within 1,000 feet consenting to the operations. While there are 4 RBUs within 500 feet and a total of 12 RBUs within 2,000, sites were using a 1,000-foot buffer pre-SB 181. Also, July 14th, 2020, PDC submitted its Form 2A application to the COGCC for the Oastman 1326 pad, which cited multiple concerns from COGCC staff in late December of 2020 due to proximity of RBUs. COGCC staff further recommended PDC to move its location with encouragement to bundle it with existing infrastructure and operations. That's how we arrived at the Whitney pad. Now, let me give you a rundown on the proposed COGCC K2 Whitney location. As previously mentioned, the 16-well Whitney pad is proposed to develop an additional 972 mineral acres from a surface location already being utilized to develop 3,477 acres. That's 4,449 acres in total from one location. This pad does connect into existing infrastructure for oil, gas, and produced water, and the additional 16-well Whitney pad will be no exception. The proposed location is outside of any high priority habitats within the 1200 series COGCC rules, no surface occupancy, wetlands, floodplain, and DI communities. There are 12 RBUs and 1 non-residential building unit within 2,000-foot buffer, with the closest RBU located at just under 800 feet from the proposed location. Roughly 92% of the RBUs within 2,000 feet are between 1,001 and 2,000 feet. As I'll explain momentarily, there was extensive outreach to these folks in consultation and opportunities to share information. I will note this site does bring in a bald eagle winter night roost site at a half a mile. However, PDC has consulted with CPW and will continue its consultations and third-party monitoring of the site now through operations. In fact, our 3 years of monitoring at this site has yielded limited bald eagle activity, which has been communicated with the CPW. In summary, this is an excellent example of the alternate location analysis working on behalf of the public health, safety, welfare, environmental resources. PDC moved the location from alternate location 2, or otherwise the Osman pad, to avoid nearby receptors, including homes less than 500 feet, minimized by scheduling operations with both the Whitney and Chalk K2 wells, and mitigating by retrofitting its facilities and electrifying production equipment. In this next slide, I'd like to highlight our neighborhood outreach. We touched each one of our stakeholders within 2,000 feet of the proposed Whitney location a total of 82 times by the way of phone calls, text messages, emails, and on-site meetings. Each and every one of our owners received an informational packet like the one I'm holding up here. As you'll note on this slide, each RBU has been given a designation. Green star represents RBU owners that have signed the informed consent packet as consenting to the proposed pad. Orange octagon representing as did not sign either consent or non-consent to the proposed pad. And lastly, the red octagon representing owners that signed the informed consent packet as non-consenting to the proposed pad. Of the 12 RBUs within 2,000 feet, 73% of active RBUs executed our very detailed informed consent packet as consent with no concerns. During our neighborhood outreach, it was identified that RBU 9 was abandoned, and with dialogue from the owner, there is no intention for the home to ever be occupied for this foreseeable future. RBUs 2, 3, 4, 5, 8, 10, 11, and 12 all consented to the informed consent packets and noted questions such as timing of operations, duration of operations, traffic haul routes, and sound DMPs. RBU owners 6 and 7, while not opposed nor against the addition to the 16 wells, elected not to sign consent or non-consent. Like the others, in-person meetings were held with these folks and walk through the informational packets and answer any questions. We fielded similar questions about operational timing, duration, and operations and traffic. Lastly, RBU owner number 1 signed non-consent. After many interactions with this owner, it was apparent that they indeed understood the information provided and while not opposed to the operation or oil and gas in general, but rather the multiple occupations within the last 4 years. You see, this has been a very amicable relationship over 4 years. While the neighborhood outreach was a major milestone in our quest to obtain informed consents, this was not the first nor the last time we will have dialogue with RBU owner number 1. PDC has and will continue to work with this owner on upcoming operations. As previously mentioned by Vanessa, there are 12 Chalk K2 wells approved by both COGCC and Weld County that have not been drilled or completed. After the many discussions with RBU 1, PDC has made the commitment to not proceed with operations on these 12 wells until the Whitney wells can be drilled sequentially, both drilling and completions, or in the same occupation. PDC's drilling and completion schedule has been revised to accommodate that commitment and minimize the impacts to the community with feedback from owners. With that, I'll hand it over to Brian Coshier, PDC's Manager, Operations, Compliance, and Policy, to detail our BMPs and mitigation measures.
Thank you, Brian, and thank you, commissioners and staff, for your time today and in review this application. I want to start today by reviewing how we intend to build and operate this location. As we have mentioned, the Whitney will be an expansion of an existing location consisting of producing and undrilled wells. The new disturbance for the Whitney wells will be on a previously reclaimed lands from our Sealy Federal Development. We anticipate the construction on this expansion to be on the order of days, not weeks. We will utilize the same construction equipment as that of what you see to build subdivisions or highway expansions, as we do not own and operate any of this equipment. However, the vendor that does 80% of PDC's work in constructing new pads does utilize all Tier 4 engines. We are currently working with our other vendors that we utilize to understand the makeup of their fleets. The drilling at this location will be Tier 4 generators fueled by diesel. As we have displayed before and are committed to in the future, we strive to electrify as much of our operations as feasibly possible. This location is the perfect location to illustrate the complexities of this endeavor. PDC put an initial load request for the Sealy facility in January of 2021. We are 2+ years later, and we do not have power at that facility to date. We anticipate it being tied into the grid in Q3 to Q4 of this year, nearly 3 years after we started the planning. The challenge is the load capacity available is not enough to service both our facility and drilling rigs. Therefore, we cannot power both, and we will have Tier 4 rig to drill the Chalk, K2, and Whitney wells. We've explored other options, and just like our facility designs, our strategy is to electrify and eliminate all emission sources at our locations. To convert to natural gas generators, we anticipate that'll be 12 to 18-month lead time, which at that point, all of our rigs will be running off of line power. So based off these factors, PDC made the decision to push harder on electrification than to pursue alternate combustion source at our locations. As for frac, we have calculated within our Form 2B emission inventory that we will be using a Tier 4 dual fuel engine with an approximate 60 to 40% composition of diesel and natural gas respectively. However, we are starting to deploy pieces of equipment on our E-fleet for hydraulic fracturing next week. We are committing here today that if the fleet rolls out as expected and is operationally sound, we will utilize the E-fleet to conduct hydraulic fracturing operations at this Whitney location. I would also like to clarify, as I mentioned, there is limited capacity on the grid. An E-fleet is not electrified from the grid. Rather, it has its own independent natural gas reciprocating generators that provide power to an entirely electric-driven fleet. This has dramatic reductions in emissions, which Meredith will go over, but also noise, which is a very important secondary reduction. A major benefit to PDC reoccupying this facility is that we will retrofit this facility to our current facility design. This will be a tankless hydrocarbon facility with all compression driven by line power. By retrofitting this facility and updating the way at which we operate to our current practices, we will result in substantial emission reductions compared to how it currently stands today. Another major advantage of this reoccupation is that all pipeline infrastructure, including water takeaway, is already built to the existing facility. There will be no new disturbance or construction needed for the Whitney to have three-phase takeaway from the time it commences production operations. I also want to point out, except for electrified drilling, all the BMPs we presented in the Guanella CAP will be executed here at the Whitney, with the potential addition of an E-fleet for frac. As we shift into related impacts, the retrofitting of our facility will have dramatic reductions as it relates to noise, with up to 7 decibel reduction. If we can deploy the E-fleet for frac, we can expect a similar reduction of decibels. Our goal is to eliminate sources of impacts, but as an additive protection, PDC has a very robust noise monitoring program that will be in place prior to drilling. PDC will have 4 continuous noise monitors deployed in the cardinal directions of the residential building units. When combined with our ambient survey, which we will conduct prior to construction, we are able to evaluate our potential impacts in real time and respond with mitigation strategies to minimize even further. PDC's tankless design significantly reduces the potential for spills and leaks during the production phase. AVO inspections are conducted daily for spills, leaks, and other contaminants. It is PDC's intent to keep chemical storage, refueling, and staging more than 500 feet from any ordinary high water mark. This location is situated within a mapped bald eagle winter night roost. PDC has been monitoring for roost activity for 3 seasons with no eagle activity observed. As mandated by Rule 309E1, PDC has consulted with CPW in 2022 and 2023 and commit to continue monitoring for roost activity, as well as additional consultations with CPW throughout the development. I will now pass the presentation off to Meredith Knopf, PDC's Air Quality Policy Advisor.
Thank you, Brian, and good morning, commissioners. Before I speak to the emissions at the proposed Whitney facility, I want to take some time to discuss some of the technologies and programs PDC utilizes to monitor emissions at all our locations. First, PDC's locations are equipped with 24/7 remote monitoring and state-of-the-art cameras to detect leaks as small as the deep exhale, as well as smoke, fires, and trespassers. Additionally, automation towers are installed to provide remote shut-in capabilities, and guard shacks are on site during drilling and completion operations for additional site security. Next, PDC also has a best-in-class air monitoring program to ensure these facilities are operated to minimize and mitigate emissions associated with leaks or other non-routine emissions. PDC is compliant with the Air Pollution Control Division's air monitoring program. This facility will have an air monitoring plan approved by the division and will have between 4 and 8 monitors dedicated to continuous VOC monitoring and passive benzene data collection through drilling, completions, and the first 6 months of production. So far, PDC has collected over 1,600 benzene samples and over 15,000 hours of continuous VOC monitoring at 23 locations during pre-production and production activities. We have only had one exceedance related to PDC operations, and that was a produced water spill within containment that was detected and mitigated quickly. Not to put too fine a point on it, the design changes that Brian just spoke to in the previous section will have a significant impact on emissions from the facility's existing design. The elimination of hydrocarbon storage tanks, which currently there are 8 on the COGCC right now, the move to electric powered engines from 4 natural gas fired engines that are currently on site, and the addition of emissionless swabs and unloads and other maintenance activities, to name a few, will result in a 61% reduction in NOx emissions, a 75% reduction in VOC emissions, and a 91% reduction of HAP emissions, despite the fact that the well count will increase from 26 to 54, and production will increase by 400% from the most recent last 12 months of operations. Next slide. I would also like to address a modification we have made and wanted to point out our pre-production emissions from our original application. PDC started the emission estimates for the Whitney wells in early 2021, where we confirmed average completion times per well at 5.9 days. However, in the past 2 years, PDC's completions program has gained operational and technological efficiencies, reducing completion time to about 2.7 days. Upon further collaboration with CDPHE, PDC chose to use actual fuel use for this recalculation effort, as it more accurately represents the emissions from the completions and drilling engines. PDC is sharing the new emission estimates of 3.14 tons of NOx per well from the 20.07 tons of NOx per well in the original application. These revised numbers more accurately capture PDC operations in 2023. Additionally, PDC endeavors to use an E-fleet to execute completions at this location, not only for the 16 Whitney wells, but also the remaining CHOC and K2 wells that will also be completed during this occupancy. The use of the E-fleet may further reduce NOx emissions up to 56%. Lastly, PDC has publicly committed to continued emission reductions for all its assets in Colorado and Texas. PDC plans to reduce methane intensity by 70% and greenhouse gas intensity by 74% by 2030, and to achieve zero routine flaring in our Texas assets, which we've already done in Colorado. To further assert our dedication to emission reductions, PDC has also joined the Oil and Gas Methane Partnership 2.0 in 2022. The OGMP is a multi-stakeholder partnership sponsored by the United Nations, the Environmental Defense Fund, and the Climate and Clean Air Coalition to improve the accuracy and transparency of methane emissions reporting. By joining this partnership and in the spirit of working with the governor on his ambitious NOx emission reduction targets and any other new or pending changes to the attainment status in the DJ Basin, including PM 2.5, PDC is committed to reaching our targets and to continuing to explore and implementing new technologies with our industry partners to continue to minimize our impact to human health and environment in the communities where we live and work. I will now hand it back over to Vanessa for PDC's closing thoughts.
PDC has guaranteed that vigorous operational protections will be in place to ensure avoidance, minimization, and mitigation of adverse impacts to public health, safety and welfare, the environment, and wildlife resources. These practices include, but are not limited to, avoidance of sensitive receptors, retrofitting to a tankless hydrocarbon facility, oil, gas, and water takeaway, sound walls, daily inspections at production facilities, 24/7 remote monitoring, remote shut-in capability, and most importantly, ensuring a true net benefit of land back to the community, as well as providing emission reductions for an existing production facility, all while adding additional wells. We would like to extend our appreciation to the staff, director, and commissioners for all the hard work on the Whitney OGDP. Thank you very much, and we welcome any questions that you might have regarding this application.
Mr. Chair, you're muted.
All right, now I'm unmuted. I'm double unmuted. I'd like to call upon Doug Andrews for additional elaboration from staff with regard to the director's recommendation and staff's thoughts about the 604B4. Mr. Andrews?
Yes, thank you, Chair. Can everyone hear me?
Yes.
Okay. The Oakland staff has a statement we would like to read into the record concerning this OGDP, if I may. Staff wishes to acknowledge for consistency with previous reviews that although it is not specified in the director's recommendation, PDC is seeking to cite the working pad surface for the new activity at the existing Chalk-Sealy Whitney location, less than 2,000 feet from one or more RBUs, as conditionally allowed by Rule 604B4. PDC did not obtain a signed letter of informed consent from all RBU owners within 2,000 feet of location. Therefore, PDC asked the Commission to find that citing the new wells at this location and the submitted BMPs will provide substantially equivalent protection per Rule 604B4. Staff determined, as stated in the director recommendation, that the BMPs provided in the permit application adequately minimized and or mitigated the potential impacts to the RBUs within 2,000 feet of the working pad surface. While inferentially this addressed the requirements of 604B4, staff did not specifically analyze whether the BMPs satisfy the substantial equivalency requirement of 604B4. However, staff reviewed this permit to ensure compliance with the requirements to avoid, minimize, and mitigate impacts to RBUs within 2,000 feet and recommended approval of the OGDP as the OGDP based on staff's review complies with the requirements of the Act and rules based on the BMPs offered.
Thank you, Mr. Andrews, for that additional comment from staff. With that, we would open this up for questions from commissioners. Commissioner McGowan had raised her hand first, so the chair recognizes Commissioner McGowan.
Thank you, Mr. Chair, and I apologize if my microphone is funky. I can't figure out how to fix it. I'm wondering if Mr. Co-Chair could, I'm not sure I'm understanding the 12 to 18 month time frame and the comment by which time we would be electrified anyway. I'm not sure I understand what you're trying to say there. I feel like testimony in your documentation shows that electrification for the drill rig is not possible because of the loading issues on the system. So I'm not understanding this additional comments of the 12 to 18 month timeline by which time we'll already be electrified. So I'm confused, sorry.
Don't apologize. Thank you, Commissioner McGowan, for the question. So last year we took an endeavor and we saw two roads, or a fork in the road of paths to go down. It was to retrofit our rigs with natural gas generators or pursue electrification. So at that time, when we went down that analysis, we were told by our vendors at that time it would be 3 years due to supply chain issues to get natural gas generators out to our rigs to retrofit and replace the diesel generators. So at that point, and if you looked at our previous applications, particularly the Guanella CAP, that's when we made the decision that PDC is going to pursue electrification at all of our locations for our drilling rig. So we kind of went down that path, not retrofitting our rigs because we would be well into 2026, 2027. Now, this year, we reached out and we're looking at a 12 to 18 month time frame to get natural gas generators. And what I meant by the time they would come in, all of our rigs would be on line power. When we go into 2024, we are looking at, we'll have essentially 3 rigs beginning of the year, 4 rigs mid-year. We're looking at all of our rigs being on line power. So by the time those natural gas generators would have came in, they essentially would have been obsolete because we're just tying into the grid. So that's what I was just trying to explain is, we had a critical decision point, either find an alternate combustion source for our rigs or electrify. We chose to electrify, thereby eliminating all of our scope 1 emissions at our location and converting them to scope 2.
Okay, so I want to make sure that I'm understanding. Regardless of your plans to have rigs that are electrically powered, for this site, that is not a possibility, even if you had those rigs today. And even if you decided you wanted to use natural gas, that is not available because you've gone the electric rig route. So the reason you're still proposing the diesel tier 4 is because those 2 other options are not available. I just want to make sure I'm understanding.
Yeah, and this location has illustrated the complexity of working to tie our operations into the grid. There's a lot of competing industries, there's a lot of new residential industries, all putting pressure on our utilities. Now, this is north of Greeley, and it's not that far north, but it's a rural area. And we have been working for 2.5 years at this point to just get line power to our existing Sealy Federal facility. The issue is the constraints and also the limited capacity. And as Vanessa showed, this is the kind of the last development in this area. So if there was capacity to bring, there's really no, we struggle as an industry because we have a high demand load up front, and then it kind of peaks down and then flattens out. So, the design has to be for a very large load that will eventually be pretty much cut in half, a year or 2 down. Okay. So with this location, due to where we are in, the kind of the rural area, there's very limited capacity on the grid to bring to this location. So we made the decision of, we finally will get it there. Like I said, we're looking at probably August, September timeframe to tie our facility in. But the capacity we have is only enough for the facility, and we cannot have the rig on it as well.
Okay. So for me, I'm trying to figure out substantial equivalency along with and parallel to our avoid, minimize, and mitigate hierarchy.
Mm-hmm.
And the fact that you have one RVU that is 787 feet from the pad. And so I'm looking at noise and emissions, and I'm looking at, from what we've seen from applications, we see the most emissions during drilling and completions. And then for those facilities that go tankless, we see a dramatic kind of drop long-term, which is very, very much appreciated. There are things that I think are commendable about this application. The going tankless to reduce emissions long-term, even though you're going to add more wells, there will be a total fewer reduction in emissions, which is important because you're going to be close to people. So I'm really kind of focused in on where I think we're going to have the most emissions and the most noise, which is during drilling and completions. And so I'm going to set aside the fact that I can't maybe get what I want for electric or natural gas drill rig and talk to you about the E-fleet. And I know I keep talking about the YOTA quote, which is do or not do not try. This is available or it isn't, and are you going to commit to this or are you not today? Because I think that that's going to be an important component for us to reduce emissions during the period where we see the most emissions from this activity. And I think also from a noise perspective and from our non-attainment ozone perspective, that's an important commitment from you all.
Yep. So thank you again for the question, Commissioner McGowan. I'll start with the production facility. Our goal and what we proposed was, yes, we're reoccupying this, but we almost view this as a beneficial reoccupation because we're going to go into that existing facility, remove all oil storage tanks, convert all compression to line power, and really change the way we operate with emissionless swabs and unloads. So if on a per well basis, if you're looking at NOx or VOCs, the production emissions are next to nil. The emissions that Meredith presented, and I believe it was somewhere about 3.1 tons per well of VOCs and similar to NOx. If we look at the makeup of that, we're talking really pre-production at this point. And 2/3 of that comes from our completions activity. So, when I said we are committing here today that we'll use an E-fleet, if it rolls out and operates as we expect, it's coming in next week. Pieces of it are coming in. It's kind of piecemeal. We'll be swapping out pieces of equipment over the next few weeks to months. Right now, as it currently stands, this location is on our first rig line or frac line, which is we operate about 1.6 frac crews per year, which means we have one continuous one and one that comes back and forth for about 7 months. This location is on the continuous frac line. And like I said, we're committing here today, but we just want to see it and make sure it performs as expected, and it'll absolutely be out there if we still have this frac fleet in the next few weeks. But if you want a firm commitment, I can say we will commit to utilizing this E-fleet if it operates as expected. If that's not firm enough, I can
A little clause in there that I wish we could take out. Those are my questions for now. Thank you.
Okay, but I can chat with others internally to see if that is a possibility.
Okay, thank you for the questions and answers, Commissioner Messner.
Thank you, Mr. Chair, and thank you for the presentation. And Commissioner McGowan asked a few of the questions that I was going to ask, so thank you for that. But I do want to ask. You're going to have to help me here a little bit, because we've got some existing wells on there, maybe 16 wells that were previously permitted that 5 years ago still haven't been drilled, and now we're concerned about a timeline associated with an E-frac fleet, and because it may not come in time, and you want to make sure that you've got this production schedule. So I guess I'm having a hard time reconciling why it wouldn't be possible to wait until you have the appropriate equipment in order to be able to provide the best management practices necessary to perhaps show up substantial equivalency, as you're indicating that this is one of the things that would provide that substantial equivalency. And so I'm having a hard time understanding that as a maybe.
So I'll start with the existing wells. We have 26 producing wells on this location. We have an additional 12 that have had surface holes set, to execute those permits. Now, to give you a little look into the landscape, SRC and PDC merged in January of 2020. At the time of the merger, the Sealy Federal wells were being drilled. So those 26 wells are being drilled, and later came on to production later that year. Now that we're one company, we evaluated the acreage as a whole, as Mr. DeRose pointed out, with the existing Osterman and his contact with the residents, and decided to hold off drilling and completing those additional 16 wells, knowing that we were going to try to consolidate the location, so we would just have one occupation to drill the 20 additional wells at that location, and immediately move that rig off and follow right up with frac. So when we talk about one occupation, we are really talking about just continuous from the time the drill bit spuds is continuous to the time the last well is fracked and brought onto production. So that was the mindset. We transferred from the mindset of two companies into one, and how we do this more protective. Now with the E-fleet, I'm not saying that we're worried about the equipment coming in. I was just strictly saying, and we were supposed to have this out in March and operating it then, so I was hoping by this time we'd have it on the ground. We just wanted to ensure that it operates as efficiently as we expect, which we're very confident in, but it's tough to have a full commitment when you don't have it on the ground, and understand its capability. So like I said, I am actively typing right now to see if that is something we could just fully commit to
Well,
regardless.
I appreciate that, Mr. Koshier. I mean, I do understand your situation, but do understand in lieu of a firm commitment, at least from this commissioner's standpoint, I have to assume that you're proposing substantial equivalency based on not utilizing that. And so that just is what it is. And I'm not saying that it's one way or the other as far as how I would ultimately determine, but it does change your argument as far as
Absolutely.
how you're, how we develop a finding of substantial equivalency. So it is important. I will jump onto another question though. As far as, I mean, 54 pads on a well, it seems like one of the bigger pads in the state. Do you have another site that has this many wells operating on it currently?
Yes, yeah, we have another site that has just about the equal amount of wells, and we'll have a couple future sites that will have similar amount of wells.
Okay, and so if on those pads that have a similar amount of wells, as you're evaluating your air monitoring program, are you evaluating it? And some of the information that you're providing is that you're not seeing any kind of significant emissions associated with pads. And so that's, again, although your argument is not clear, that's what I'm assuming your argument is for substantial equivalency. And so
Yeah, I can just start it off.
And so when we look at the air monitoring program and the emissions associated with a 54 well pad, which for all intents and purposes is a really big pad, you have experience in those pads and have air monitoring programs in place on pads of that size that you're using in order to show that this one would also be protective. Is that my understanding?
Yeah, and I was just gonna say, we have two sites. One is the Boast pad, which is a 48 well site within the city limits of Greeley. We have the BB Spur Harvard, which is a 54 well pad. And then I'll kick it off to Meredith on the monitoring that we've seen at those pads.
Thanks, Brian, and thanks, Commissioner Messner, for that question. We actually, when we cite our air monitors, we cite them based and determine the number of air monitors based on the size of the pad and the proximity to RBUs or other sensitive receptors. So likely a pad this size, similar to the Boast, will have somewhere in the neighborhood of 6 to 8 air monitors located around, and these air monitors are continuous. So we do have data, and we're using all these best management practices at this location, which also causes that reduction in emissions, not only from a leak perspective and a maintenance perspective, but also just normal operations. ECDs are now running as a backup and not a primary mechanism for VOC reduction. So we're only going to ECDs at a very intermittent nature, which also reduces the emissions as well. So these air monitors are actively capturing this, and we have that data at about 23, 24 locations to support that, of varying sizes between 16 wells all the way up to 48, with a vast majority between that 24, 36 range.
Okay, thank you for that. Now, I wonder if you could go into a little more detail. You provided a slide that indicated that based on new calculations, that there was a pretty significant reduction in emissions, but I wonder if you could back that up a little bit with where you're pulling that data from, how that's being analyzed, how are you accomplishing such a drastic reduction from what your initial calculations were?
And Meredith, if you want to pull that back up, it was slide 23, I think, and that might help in the explanation.
Thank you. And are you referring to pre-production or the production pad, Commissioner Messner? Is it this slide?
It was not
the next slide.
Yeah.
Okay.
You could explain that one too if you want.
Oh, Sure, I can do both. I'll start with this one. So this is very similar to the discussions we had during our Guanella CAP discussion. And when the CDPHE was reviewing our pre-production emissions, they noticed that we had been overly conservative in our calculations for pre-production NOx. As you know, for the Guanella CAP, we also had electric drilling. So it was mostly around completions. So we went back and we spoke to our completions superintendent, our completions team, and just refined the data based on the current state of our completions program. Technology is moving very fast. Operational efficiencies are moving very fast. And so between the time we submitted this application and we started re-reviewing our completions program, we had noticed a significant downtrend in days per completion. And that includes, the days per completion between a 3-mile lateral and a 4-mile lateral and a 2-mile lateral are very small. Actually, it's between 2.5 and 2.7 days, depending on the lateral length. And so we realized we'd basically almost doubled the emissions. And then upon further reflection, we started looking at fuel use being a much more accurate, factor for determining emissions on these sites versus days, because you're just having different things going on. So that actual fuel use is what's going to those engines and what's causing those emissions. So we went back and determined, fuel use for the period of time for 3-mile laterals, 2-mile laterals, that sort of thing, and then kind of used fuel use. And this was discussed and collaborated with the CDPHE and approved by them for this new calculation. And that's how we kind of got to that point, is just, we've just gotten better at what we do. And we're pretty proud of that. And so we wanted to reflect that in our new emission calculations. Basically, we were overly conservative when we first submitted this application. And I can
Okay, thanks for that.
the other slide too.
That'd be great, because the other question I have is, as I review this application and I'm looking at kind of what the net adverse impact of the application is. What is the reduction in emissions associated with going to retrofitting the site to a tankless design? And I mean, you could make a really good argument about reducing net adverse impacts, should you choose to utilize alternative fuel sources or electrification of completion activities for previously approved wells, as well as potentially electrification or natural gas generators associated with the drilling rigs for previously approved wells, right? But we don't have that right now, so I'm still trying to understand what perhaps some net benefits would be, and so I'm trying to understand that.
Meredith,
Sure.
if I can just jump in.
Go ahead.
Commissioner Mesner, I just got formal approval with our Vice President of the Wattenberg and Director of Drilling Completions that we have a firm commitment here today that we will utilize the E-fleet on the Whitney, Chalk, and K2. So the new permits and the ones that are already permitted and yet to be executed. So we will accept a COA that the E-fleet will be used at the 28 additional wells.
Great, I appreciate that, Mr. Coshier. I think that does go a long way to proving up your argument and being able to have a finding of substantial equivalency. I think, inevitably, if that occurs, there has to be some new math that's done as far as emissions reductions and some of the cumulative impacts pieces. But Ms. Knopf, maybe just to follow along on that question, like when we look at, and now, I mean, this is a new thing with the E-fleets and such, so you may not be prepared to answer that, but from just the retrofitting into a tankless system for the existing facility, what does that mean for reduction in emissions? What does that mean for reduction of adverse impacts to sensitive receptors?
Sure, that's a great question, Commissioner Messner, and I can answer that. I'm also pulling up some math here too, so I might be able to sort of give you a back of the envelope calculation what the use of the e-fleet might mean in terms of reductions, but keep in mind that'll be a, fast math may not be my strong skill set right now. But so this slide is specific to production. And so I want to talk to you about like what the pad currently looks like at the COGCC and how it's currently permitted and its actual emissions right now. So this facility is basically has 8 condensate tanks right now. So a lot of the emissions that you see, especially related to VOCs on this slide, are based on the amount of throughput going through those tanks at that time. We also have 4 engines on site. One's a generator that's currently powering our instrument air and our LACT and our surge that's on site. So we don't have, as Brian spoke to, electricity on site right now. So we do have that generator. We also have 2 compressor engines on location. And then we also have a VRU that's, pulling some of that gas off and getting it back down the pipe instead of sending it to the ECDs. So that's what the current design is. We also have a mix of controlled and uncontrolled maintenance activities. So even though we've reduced our swabs and emissions field wide by 90%, this facility still has the ability to have uncontrolled maintenance activities when needed. And so basically when we're going to go back in and do this reoccupancy, we're going to make some changes. We're going to reduce, we're going to eliminate hydrocarbon storage. So we'll just have maintenance tanks on site in case of an upset or a maintenance activity. So you're greatly reducing the amount of throughput going through those tanks. The VRU will move to being an electric VRU as well as those compressor engines, and we'll eliminate that generator as we'll have grid power, line power at this site once we go into production. We're also committing to controlled and emissionless maintenance activities. So our routine or predictable emissions, which can be a primary source of emissions at these sites, will also be greatly reduced by retrofitting the facilities so that those can be controlled, or will move to emissionless swabs, which takes a special swab rig, or we go through the separator. So those are the primary mechanisms that you'll see those reductions. And when you traditionally see a pad, it's those rope emissions, the engines, and the tanks. So they're the primary emission sources. So we're essentially eliminating them. That's always PDC's first preference when we can eliminate emissions, and then reducing them when elimination is not possible. And that's where you see these reductions. And the current design, this is actually not what it's permitted for. This is a little lower. This is very close to what the actual emissions may be on site over the past 12 months.
Okay, thank you for that.
And then, oh, sorry.
Well, go ahead.
I can see if I can get you a pre-production emission reduction. Let me see here.
If you need a second, take a second, because I'm
Sure.
going to ask Mr. DeRose a question.
Why don't you ask Mr. DeRose and I'll get you a better number that way.
Okay, thank you. Mr. DeRose, I wonder if you could talk a little more about the contacts and the conversations with the RBU owners or tenants that either were non-consent or did not provide informed consent. Particularly, I mean, it looks like I'm not looking at the slide right now, but maybe the in-person contacts with onesies or twosies, followed up by onesies or twosies with some phone calls, generally somewhere between 5 and 7 contacts overall with each of them. Has the non-consenting owner, does he know of your intent to go in and do all of the new proposed activities in one fell swoop? What's his disposition on that? Was it clear to him that he had the ability to share his thoughts in either the WOGLA process or within our process? Just a little more detail would be good on that.
Yeah, thank you for your question, Commissioner Messner. I'll try to unpack this the best I can here. I know you hit me with a few questions, but in regards to, I think you're specifically talking to RBU 6 and 7. What I did personally was take out these packets to every single one of these homes, and then we had an in-person meeting where we went over the packet. And while it was somewhat confusing because there's, existing wells that have not been completed, it was very much apparent once we started getting the feedback that, hey, PDC is coming back to this site, and it's going to make a much better operation if we can bundle the Whitney wells and that operation with the Chalk and the K2 wells. And so their feedback was, hey, look, we recognize that you're going to come back. These new wells, if you can you please come back and do them all at once rather than come and do these Chalk K2 wells, leave, and then come back and do the Whitney. The overall impression in the area was, hey, we're okay with the operation. We just want you to be done. We want you to get this in. We want you to get out and be done with the operation. And so, through our presentation, I think that's reflective of the commitment that we're trying to make here is that, we've got to come back on the Chalk K2 wells with our approved permits. And so bundling these Whitney wells with that operation was pretty paramount to the neighborhood, and we took that feedback and put that and reflect that in our drill schedule. But as far as RBU 6 and 7, they didn't deny nor were saying, hey, come on in. They'd rather just go no contest and move along. But they did receive the information. We do have their contact information, and we're going to continue to reach out and give them updates on our duration of operations, our timing of operations, and continue that dialogue. Did I get everything yet?
I wonder if the only other piece on there is the non-consenting RBU, which I believe is RBU 1. Has that RBU owner or tenant been informed of your intent, your proposal to do all of the remaining wells in one sitting? And I'd be interested to hear the disposition or opinion of that RBU owner if you had told them.
Yeah, and that relationship, thank you for the question, Commissioner Messer, again, and further clarification. So, RBU 1, that relationship has been ongoing for, as I explained, for about 4 years now, just, as we engaged with them at the onset of drilling our Chalk federal wells. And they are not opposed to oil and gas, and they specifically told me that, hey, we're not opposed to this, but we're just ready for you to be done. And that was really their comment back, is that, hey, we know you're going to come in, but we'd rather you just, whatever it is, can you just please be done with one occupation? And that really sung to us, and we took that back internally, and that's why we've scheduled it the way that we have. Now we're still having conversations with that owner about screening and visual mitigations associated with our operation and their property. That makes the operation and the longer, in the production phase, more palatable and comfortable for those folks as they continue to live with it. And as a good neighbor, PDC it took that, and we're taking those steps to do that with earth and berming, and working with them on what may they want to make it suitable for their needs.
Okay, thank you for that. So that I mean, that's a little bit of a local government thing as far as some of the mitigation measures around kind of long-term production pieces, and at the same time, I know that that's really important for residents, that in the production stages, particularly in areas like this, that there are significant visual mitigations implemented, and I have seen that done in some other facilities of yours, and so I know that you have the ability to do that, and so I think that would go a long way. with working with some of the neighbors there, understanding that they're going to be your neighbors for a significant amount of time with a pretty significant operation here. So.
And Commissioner Mesner, can I just add something? These RBUs were also noticed at the completeness timing, and also received a hearing notice as well for the hearing today, both at the COGCC level and the Weld level too. So I just wanted to, it doesn't stop with informed consent, as Brian said. They're part of the process, and that's why the rules are written as such. But they are fully aware of the hearing today and the one that we had at Weld, I guess it was a month or two ago. So.
All right, thank you for that. I think I'll leave it at that right now, unless Ms. Knopf, you've got an update for me.
Hi, sure. Yes, I do. This is a back of an envelope calculation, but if we can go back to slide 24, I can kind of show you really quickly. So the pre-production NOx, I just did NOx, so we'll just use that one, for example. About 2/3, a little more than 2/3 of the pre-production NOx, tons per well, is from completions. So if I use, like Brian said, we do not have a Liberty E-frac on the E-fleet on the ground yet. So this is based on Liberty's cut sheet of up to 56% NOx reductions. So I looked at about somewhere between a 40% NOx reduction and a 50% NOx reduction to be conservative. And we're looking at a reduction from 3.14 tons per well to somewhere between 1.95 and 2.21 tons NOx per well. And that this kind of reduction would also be also seen on those other 12 wells that have already been drilled but not completed. So you are seeing about a little bit over a ton plus NOx reductions by the use of an E-fleet. And that's kind of a conservative estimate.
Okay, thank you for that. I appreciate it. That's all the questions I have for now. So thank you, Mr. Chair.
Great. Other commissioners with questions? Commissioner Cross? And then Commissioner Ackerman?
Sorry. Were you wanting me to go, or Commissioner Ackerman?
Yeah, you go first, and then we'll recognize Commissioner Ackerman. Thanks.
All right. Thank you, Mr. Chair, and thank you to the applicant for this presentation and fielding these questions. And I want to start by going back to a little bit about what Commissioner McGowan asked about. In response to one of that, I believe, Mr. Koshier, you said that there's a high demand load up front. And so kind of to clarify for everyone's benefit, can you give us an understanding of what the pull on the grid is like for using an electric rig versus what the pull on the grid is like for using an electrified facility, and how much is required for that?
Yeah, so our rigs typically have a demand load of about 3.5 megawatts. Completions is in the teens. That's why we really can't even talk about the completions at this point, pulling from the grid, just because of the other constraints on the grid. For instance, they have a lot of E-fleets pulling from the grid in West Texas, but the infrastructure in West Texas is an oil field, not an urban corridor with commercial and other industries in place. Now, the facility is highly dependent on the amount of wells you're bringing on. Yes, this is a 54 well facility, but half of those are, really in their decline and really draw. So if you think about our facility, and I'm not sure if you're familiar with the decline curves of our wells, the decline curves of our wells peak and then come down and then kind of flatten out. And that is the same, because a lot of it's based on throughput. So that is the same curve that our facilities have as far as demand load. So really the demand load from a facility can be anywhere from 1 megawatt to 4.5 megawatts based on this design of what we're projecting today. Now, this one will be somewhere in the 3 megawatt demand load. But like I said, with the rig, our goal is to have the existing facility tied in, and with the rig coming in at the same time in an electrified facility, it just doesn't match up.
And again, to clarify on some of what Commissioner McGowan asked about as well, I know that there was some discussion about the timing it would take to bring in the natural gas run engine and versus what you're doing now. And so could you explain again how long it would take for the natural gas engine to be used if you're doing that now?
Yeah, if we were going to commit today, we were looking at about a 12 to 18 month time to deploy those engines and retrofit our rig with it. And
Okay.
you know, right now we're looking into mid 2024, late 24, and you know, at that time, essentially all of our rig lines and all the locations are set up for line power. You know, and any generator you have is just strictly for redundancy. You know, shall there be a blackout, brownout, whatever, you know, you have to fire up the generator. So, you know, get out of the hole and secure the operation. But our intent is really to shift everything to electrification and scope 2 emissions, not have an alternate combustion source on location.
Okay. And so I understand, obviously you're talking about kind of as a company, and with this, especially with this being kind of the last one in this development area, as you're talking about it, you've mentioned that it kind of becomes obsolete to retrofit everything for the natural gas versus by the time to be ready, everything's going to be electric anyway. But did the fact that this is going to further delay this location drilling play into account at all, especially given that some of the RBU owners in the vicinity were already saying, why can't we get this all done at once?
Yeah, and Joe, I don't know, or Daniel, I don't know if we can go back to the timeline slide. Yeah, that was our intention, is really, you know, get this one approved. So then now we're able to link them together and really, as Brian pointed out, get everything done and out of there. Walls are down, you know, the crop grows around the facility, and it's really out of people's visual lines of sight. And also, you know, now these retrofits greatly reduce the noise as well. So we really just want to get in and get out at this point. So that was the goal of, yeah, that one right there. You know, because we're looking at coming in here in just a few months after this approval, and really the time that we're talking about from today till Q4 drilling is the time to process the Form 2s, you know, the wellbore permits. You know, we can't go and drill these wells right after today. We need to go through the Form 2 process with staff. So really, that's why we had this tight timeline, is get this approved today, link them up with the existing 12 well slots already there, go through the Form 2 process and get out there and get these wells executed. So we didn't want to kick the can until the end of 2025.
Perfect. I appreciate that.
Yep.
And I think I'll go to Ms. Knopf next. And one of the things that I wanted to touch on based on some of Commissioner Mesner's comments with respect to the air emissions, could you go over a little bit what the monitoring looks like from distances? So obviously you're going to have some air emissions monitors at the site. What kind of differences are you noticing as that distance goes further out, and what steps are you taking to monitor those emissions from further distances?
So we work with landowners to site those air monitors. So we're slightly limited in where we can put them based on where landowners will let us. However, we do have a requirement to be about, I think it's three and a half times the distance of the sound walls. So when the sound walls are up, the air monitors have to be farther back. And then sometimes once we get into production and the pad footprint shrinks, we kind of move them a little bit closer. So we are trying to get that initial, you know, what exactly is coming off that pad, essentially. We haven't noticed a huge difference in where we site them based on emissions. It really has to do with what's going on pad. We have been able to pick up interesting things for sure on those monitors, nothing that will exceed a human health screening value, but we will be able to see, like, we've been able to detect leaks with these, for example, and been able to send out our crews and get that taken care of as well. We also have those Clean Connect OGI cameras that also can see leaks as well as spills and fires. So it's kind of a triple threat attack between the air monitors, the Clean Connect cameras, as well as the 24/7 monitoring. And, you know, when these pads first come online, they have daily, multi-day visits by our pumpers and field staff as well. So they're under a lot of, I guess, scrutiny by our PDC staff and employees. So it's definitely not just one pronged approach to check these air monitors.
And I appreciate that. And I think to follow up and build on that more, understanding the benefits of kind of the 24-hour monitoring and being able to detect leaks, are you noticing any differences in the amount of emissions, say from, and we'll use the numbers in here, from 787 feet away versus 2,000 feet away? Because you're noticing a lot of air emission reductions overall, but I'm kind of wondering if it's still significant emissions that then spread, like really decline by the time you get from the 1,000 to the 2,000 feet, or if it's fairly similar.
Thanks, Commissioner Cross. I don't have an answer for that. We do not put our monitors 2,000 feet away from the location. At that point, you're bringing in quite a bit of other potential emissions at that point. These do have anemometers, so we do wind direction and wind speed, so we can pinpoint when something is coming from our pad versus another. When you get to that larger radius, you're bringing in just a lot of other potential factors at that point. So I can't speak to that. I know the APCD and others have done other research along those lines, and that might be something I could send you there in the future, but it's really hard for me to say with confidence just because we have not done that kind of research, nor have we been required to at this point. We're looking very specific for that on-pad emissions source.
Okay. Based on your experience and kind of expertise, do you foresee, and looking at this from the substantial equivalence mindset, do you see any kind of issue in terms of the emissions? Now, again, noticing that you're doing overall reduction in emissions, but are you seeing a difference in emissions for an RBU that's closer than 1,000 feet than one that would be, say, more than 1,000 feet, based on your kind of expertise and experience and what you've done in the past?
Yes, so another good question that I am unable to answer. We do not do air monitoring on people's homes or thresholds, so I can't speak to that. That's kind of outside my expertise because you're getting into more into toxicological type evaluations, which we do not do. I will say these plans are approved by the division, and we submit monthly reports as well. And so they are reviewed on a monthly basis. And we also report if we do have an exceedance like that one produced water spill. We do notify the agency also and take additional samples at that time as well. So there is a lot of safeguards there.
But even at the working pad surface level, you're not seeing any kind of exceedances or anything like that that would be harmful to human health?
No. Our monitors have only picked up that one spill, which is a fairly large spill. We also had one exceedance from an off-pad operations. Based on wind direction, we were able to pinpoint a different source of emissions that were hitting our monitors as well. And so we were actually able to relay that information to the other party to let them know that they had some higher emissions coming from their location. But otherwise, no, we don't see. I did have some slides previously where I kind of showed that information. Most of us these are very low. We're talking baseline type emissions that you see. We do go out there for about 10 to 30 days prior to any kind of occupancy and do take baseline. And very rarely do we see things above baseline. You might see an occasional blip if that's a maintenance activity, that sort of thing. Sometimes we have cars parked close to our monitor, so you'll see things like that as well. But for the most part, it's baseline emissions at these sites. Again, our goal is to eliminate emissions. So especially with these newer sites, there's just not as many emission sources for these monitors to pick up in general.
Okay. And then one final question for you, just for clarifying one of your last points there. So on, I think it was slide 20, slide 24. So a couple down from where you are, you said the 3.14 tons per well is without the e-fleet, correct? And then it was down to 1.95. So even further reduction if you using the e-fleet that you're committing to today.
Correct, yes. Based on my back of the envelope calculation and the information we've been provided by the e-fleet operator, I did a conservative estimate between 40% and 50% NOx reduction, and that got us down to 1.9 to 2.2. Again, I'm going to caveat that as a back as an envelope. We have, as Brian mentioned, has not deployed the e-fleet. So once we do that, we'll be able to see real reductions based on our actual fuel use and data.
Okay. Perfect. And I think next I want to go to Mr. DeRose quickly. Can we go back and talk a little bit about alternative 2 again? Get to the... And so for clarification, this was initially where you wanted to drill these wells from, correct?
Yes, that is correct.
Okay, and you mentioned the suggestion from COGCC that you try and consolidate the locations. Was that done at the pre-application with Weld County? Was that done separately from the pre-application with Weld County? Can you go into a little bit more detail on that?
You bet. Thanks for the question, Commissioner Cross. So, yeah, I mean, it's obviously taken quite the evolution here, but under SRC and prior to the merger with PDC, SRC had secured a surface use agreement and also secured a use by special review with the city of Greeley at this particular site for the 16 wells that we're contemplating here today at what is now the Whitney pad. And that was that pre-SB 181 lens that we procured the surface use agreement, procured our permit package on the 2A, and submitted our use by special review with the city of Greeley. I think, towards the end of 2019, when we processed all this, we had submitted our Form 2A, and it was, we had where you can see these red boxes kind of to the south of that pad. We did have homes within less than 500 feet from the working pad surface. And, they were actually agreeable to the location. However, when we decided that, we really kind of need to take a look at this once we knew that SB 181 really was going to come into play and that we were going to be processing this kind of under the new rules. It was, hey, let's just pull this permit back. And that's really when we said, okay, let's take a deeper dive into what the alternate location analysis is going to look like. Over that evolution, it has really provided us with more technologies in our ability to step out, or the technologies with our drilling program, that we're able to bundle this with the chalk and the K2 and the Sealy wells that are already present. And it made a lot of sense, both from, a design standpoint, an operational standpoint, and from, creating one surface location, but inadvertently, right, it's created that extra occupation. And I think that's why you're hearing us today say, that's why it's very important for us to group these 16 Whitney wells with the chalk K2 wells in that one occupation. So I hope that maybe answered your question and gave you a little bit more color, but that's kind of the origin and really the evolution kind of at this particular Oastman site.
No, and that makes sense. And to clarify as well, there would have been an additional facility at this location as well, in addition to what's at the now proposed location, correct?
That would be correct, and additional oil, gas, and produced water takeaway, which is what we committed to with the city of Greeley. So we would have not only seen a production facility and a well pad here, but additional existing infrastructure that would need to be routed to this particular site for that takeaway. Correct.
And then final question with relation to that. kind of understanding that things had changed, and obviously this was a couple of years ago as you started to change this location, but did you do any kind of quantification of impacts using that location as well as the now proposed location? Or had you not gotten to that stage yet? And in terms of impacts, not just being obviously surface disturbance, which we can see easily, but any kind of emissions impacts, things like that.
I might send that over to Brian, but I don't believe that analysis. Brian, I'll let you take that one.
Yeah. Thanks, Commissioner Cross. Yeah, as Brian alluded to, we submitted this in 19 and thinking about the rollout of the mission change rulemakings, this was mid 2020 that Brian was talking about, us working with staff and eventually pulling the application, and the rules, and Chair, correct me if I'm wrong, were ratified in November of 2020 and implemented January 15th of 21. So we were not operating under the guise of the Form 2B and collecting all of your emission data, your surface impacts, your land use data, and evaluating at that point. We were just working with staff under the lens that this is coming. So let's start evaluating that, but we don't have the tangible evaluation to compare the quantitative additive nature of the two separate locations. So
okay. I believe that's all the questions I have for now, Chair. Thank you.
Commissioner Ackerman.
Thanks, Mr. Chair. Appreciate that. I just also wanted to agree that I appreciate PDC's work on this application. With all applications of this size, it's substantial, it's complex. There's a lot of work, a lot of outreach, a lot of technical details, and I appreciate the detail that's been provided. My short experience with PDC has been one of a company that's working diligently towards reducing emissions, which is so important to our state, one who proactively monitors and adjusts its own operations in real-time detail, who consistently attempts to work cooperatively with affected parties and receptors, and consistently works to improve BMPs and operational procedures. So I wanted to recognize PDC for that and thank you for those efforts, and encourage you to continue to employ those practices of consistent self-improvement. That said, obviously PDC activities continue to have impacts and there remain opportunities for improvement. And I appreciate the questions and comments from my fellow commissioners, since we're all kind of gravitating around the same issues, and many of my questions have been addressed in your responses. So I'll just focus on a couple of points within those questions that I could use a little more clarification on. And really my primary regulatory concern with this application has to do with the 604 B4 substantial equivalency, absent full consent of all RBUs within 2,000 feet. Wanted to note that I appreciate Mr. Andrews from staff providing further staff comment and insight on staff's philosophy of approval in the director's recommendation regarding substantial equivalency regulations. So as has been stated, we've got, siting within 2,000 feet with the consent, I believe, of 9 of 12 parties, and 2 did not signs and 1 non-consent, that 1 non-consent being the closest building. Through PDC's written and oral testimony, I've heard that there was significant conversations with that RBU owner and all RBU owners that would talk. And so I appreciate you providing us with those details of those communications. And my understanding from PDC's testimony is that RBU1 generally is supportive of the development that's taken place in the area, but being the nearest home, their primary concern is the reoccupation of the pads. I did want to just give one side note here. I appreciate your presentation pointing us to the ALA presentation of many of the applicable regulations in 604B4. I would just give as a working note in the future, in the event of non-consent or lack of specific consent of RBUs, a specific analysis of all 604B4 substantially equivalent regs would be very helpful to an application, in my opinion. So on the point of reoccupation, I think this is a great point made by the owner of RBU1, and single occupation of a site obviously is a great way to acknowledge with and work with otherwise cooperative affected land and homeowners. And so I wanted to ask you a little bit about that point. My understanding, well, I wanted to ask about the business model of leaving wells drilled to surface casing only, and why 12 wells were left drilled to surface casing only. I get that. I get the point that you wanted to, once you realize you were going to do more wells, you wanted to come back in and do them all at the same time, which is admirable. But why weren't those 12 completed during the initial phase? And if you could also address, my understanding is that that's not a one-off situation, and that there are other instances in which wells are left drilled but incomplete under other PDC permits. And are you seeking to, eliminate the business practice of incomplete drilling of some wells to surface casing only, thereby, kind of removing this issue of potential subsequent drilling and fracking occupations? Again, understanding that this one's a little unique in that additional wells are being proposed, and I appreciate you, consolidating them all into one additional occupation. So hopefully that makes sense. If not, I'm happy to clarify, but would appreciate you kind of addressing that point.
Thank you, Commissioner Ackerman, for the question. We have a surface rig, or a sputter rig, we call it, that is separate from our larger production rig that goes to drill the wells through the production interval to depth. The reason why we use that surface rig is it's a much smaller impact. I mean, you can barely see the derrick outside of the walls, but we drill these surface holes really in about 0.6 days. So to drill these 12 wells to set surface, we're really doing it, and we're talking on the order of magnitude of 6 or 7 days. It's just a lot more of an efficient operation. We do use oil-based mud for our bigger rigs, and we use fresh water for that smaller surface spud rig. Just to give you a little backdrop of the landscape, like I said, the merger of this, the drilling at the Sealy Federal wells occurred during the merger of SRC and PDC. At that point, cumulatively, we had 5 rigs running, and then that was January of 2020. And then we also had pretty healthy drilled and uncompleted well inventories. So if you look at what happened later that year, i.e. the global pandemic, where all activity really ceased, we dropped from 5 to 1 rigs. We built a pretty healthy permanent inventory. It was fortunate for us because others were in different situations, and we had a healthy duck inventory as well. But when we viewed this development, and as Mr. DeRose said, going into 2021, and realized the opportunity we have with consolidating the Whitney to this location, those Chalk K2 wells had permits, wellbore permits, not location permits tied to it, that were expiring. So we went with that much smaller rig in a very short time just to execute those permits, set surface, knowing that for the big rig and frac, we wanted to combine these. And when we're looking at the cadence of our permitting, we're at about 6 to 7 months from submittal to hearing, and probably on the order of 4 to 5 months for us to develop a package. So that was kind of the extended period too. Once we decided to go with this strategy, it took us a year from starting on this consolidation to where we are today. So that's really, it was just a merger with a tremendous global pandemic and downturn that led to decreased activity, and then just kind of an abundance of permits that we when we pick back up, we try to have a strategy to execute.
Thanks, Mr. Cocchieri. I appreciate the response. And so what I'm inferring largely from that response is that the duck inventory is a result of a number of issues that you've talked about, and that your current practice is not to propose wells and have some drilled only partially complete, just a surface casing. Yep. That's not.
Yeah. So for the Guanella cap which we just heard, wow, I guess it's over almost 5 months ago at this point. We proposed with the Guanella cap that we would have that surface rig and the production rig tied into the grid, which is a basin first. I think there's really only one surface rig on the west, maybe US onshore, that has that capability to electrify its operations to drill surfaces. We have that rig under contract. Now, getting line power to these locations is not an easy endeavor all the time. So we are really shrinking that time period between the surface rig getting there to the production rig, so that we have probably 2 weeks, 3 weeks most in between those rigs, just for some flexibility if we were to have, you know, downhole issues or whatever. So that time frame has really shortened. And for reference, you know, we set, like I said, we set surfaces in about 0.5 to 0.6 days per well. And, you know, based on the lateral length, we'll have the production rig drilling the rest of that well, casing and cementing, in anywhere from 3.5 days to 6 days, depending on the lateral length.
Thank you. Appreciate that. And that's a good segue into kind of my follow-up question, which really touches on questions asked by other commissioners. I wanted to say I appreciate PDC's responsiveness to the governor's direction to reduce emissions and to move to electric rigs. Appreciate the discussion that's taken place here today surrounding that topic. And I think that PDC's commitment to move to all electric drilling within 18 months is realistic and responsible. To me, of course, the elephant is, will line power realistically be available in 18 months? And is PDC actively working with electricity providers to plan for that, to fund it, to help them understand the capacity that will be needed in the locations where it will be needed? I mean, how are you working with applicable electric companies to provide the power down the road in 18 months, avoiding the situation, you know, that we're addressing today?
Yeah, thank you for the question, Commissioner Ackerman. And you know, that's a challenging endeavor. You know, you cannot reserve capacity on the grid, meaning you can't say, hey, we're going to be here in 2024, reserve X megawatts for us. But really, I think if you look at kind of the new regulations, the long-term planning, the predictability of it is really what the utility providers have lacked in the past, you know, where, you know, high commodity prices, we pick up 6 rigs, and low commodity price, we dump them all. To now we have a very predictable regulatory environment in which, you know, we're kind of shifting from like into a long-term planning mode. So now we are looking at our electrical demands similar to the way we look at pipelines, in that, you know, we are giving our midstream providers years of projections of where we're going to be, the volumes we're going to be. And similarly, we're now doing that with the utility companies. The CAP was a perfect example. We started talking to them in 2020. God, I think it was even 2020, because, you know, it was right after the merger. We talked about the project coming over, just to really start to plan and talk about timing and demand load and really how it all works within their grid. So really the framework we have, I think, it adapts pretty well to providing long-term planning for these utilities. Now, in the case like the COGCC, it's just not there for us to have that demand. But with time planning and then, you know, capital outlay for building the infrastructure to your locations, you know, we're pretty confident that we're going to be able to execute our plan of shifting our whole rig, all of our rig lines to an electrified fleet.
Thanks for that clarification. I appreciate that. And I know it's not needed from me, but I continue to encourage PDC to work closely with the electric companies to you know, plan the best that we can in order to provide that power. Such an important approach for large productions such as this one. Mr. Chair, I think that's all the questions I've got for now. Thanks.
Great. Good set of questions from all the commissioners. Do others have follow-up questions? Commissioner McGowan?
Thank you, Mr. Chair. And my apologies if this was already discussed. Is the estimated time that you all will be drilling to completions? I think I read 9 weeks, but that, am I way off? How long are you going to be occupying the territory?
Can we bring up that slide again, Daniel? That goes to the phases. Yep, it was just right there. So really coming with construction in Q3 of this year, followed by drilling starting in Q4 and through Q1, and then completion activities Q2 2024. So we're looking at 9 to 10 months of activity.
Okay.
Like I said, you know, typically we have a gap between drilling and completions. Right now on the schedule, we have about a 2-week buffer from when the drilling rig leaves to when the completion crew comes in. So it's about as continuous as we can get from drill to completions. You know, in this way, once the wells are on production, the walls come down, reclamation happens, and like I said, those crops then kind of really snug up to the well pad and facility, and then you start losing line of sight. So,
Thank you.
and Brian, is it corn that's around that location?
Yeah, that is correct.
Okay.
Other final questions for the panel? All right, with that, we move into the deliberations mode. Does anyone care to initiate deliberations? Commissioner Cross?
Thank you, Mr. Chair. I'll start off by saying I believe that this application should be approved. You know, from a high level, I think it's important to note that PDC is taking steps to go above and beyond our regulations, working with landowners, working with Weld County, working with the COGCC staff, with CPW, et cetera, to try and make sure that they are doing everything they can. And the voluntary efforts that are being made, and we're seeing this not just from PDC, but for other operators as well. I think it's important to see those voluntary efforts to try and make sure that we're reducing emissions, that we're taking steps to electrify, to work with Excel, as Commissioner Ackerman mentioned, to make sure that we're getting things set up and moving forward, and making sure that we're taking the appropriate steps for water protection and other protections. So I'll start off with saying that I think, to me, the one thing that sticks out there in this application is obviously the non-consenting RBU owner. And admittedly, this is a little bit of a conundrum because
Commissioner Cross stopped talking, or did he freeze?
He's frozen.
Frozen, that would be deep thought even for Commissioner Cross.
Okay, let me text him because he's probably eloquently saying something that we're not hearing. Let's give him a second. Let's do this. Let's take 10 minutes and give Mike Cross a chance to get back in. Let's return at 12:13. Our commissioners back. Recording is going. Commissioner Cross, you were eloquently saying a lot of things in a frozen mode, so would ask you to perhaps start over.
I appreciate that, and I actually promised that I was not saying anything eloquently, mostly because power went out everywhere in our neighborhood. So I kind of knew that I was no longer on. But the second point that I wanted to go into was the concern with the nearby RBU. And what I was hoping to say is we're in a little bit of a conundrum with this situation, because this is not someone that just didn't initially not provide consent one way or another, but it's someone that signed a non-consent. But even with that said, what we're getting from this landowner is also a little different than someone that is opposed to it. Both PDC in their testimony today indicated that this landowner actually is not opposed. They were fine with what was occurring beforehand. They appreciate PDC working with them. And when you read through all the comments and the discussions that they had with this landowner, they actually full out said, and I'm going to read from the notes, that they actually understood the concept of having the combined surface location and appreciate it, but they would have still liked everything to be drilled at once. And in fact, they would have liked everything to be drilled from that location at one time. So that also makes it an interesting situation as well. And a week after that communication, they spoke with that owner again, and it says they're appreciative of making accommodations with the berms, the landscaping, et cetera. but decided not to give consent. So even in that situation, it's not a situation where they're saying, we're now opposing it. It's a situation where they're saying, we're not going to give the informed consent. And so it's a little bit of a tough process, but I think what really sticks out to me is the fact that this is a landowner that's not opposed to the oil and gas development, not even at that location, but is just frustrated. And I can completely understand and appreciate that frustration with having to come back in. But that said, there was no attempt to protest this application. There was no comments given either at the WOGLA process, at our process here. And so I think that's telling as well, even though this landowner was notified of the ability to give those comments. And I think what really sticks out to me as well is what the alternative is for that landowner if this was not to go through. Because even if we were to pull this application and look at another location for these wells, there's still wells that are approved to be drilled at that location. And so it's also a little bit of stuck between a rock and a hard place with what's going to happen there for that existing permit. And so with that, I think when you look at some of the alternative location analysis and see that this, for other reasons as well, but really I think that this is the best location for drilling these, because you're going to get the benefits, get in there and get out. And so I do think it's appropriate to speak at depth about this landowner and the concerns, and hopefully, obviously some extenuating circumstances given the merger that occurred a few years back, and kind of creating that, what are we going to do and how are we going to try and do this in an organized manner when you're bringing two companies together. But I do think it's important to kind of go in depth on why I don't think that the non-consent is going to prevent me from voting for this application. Next, I want to go into specifically the substantial equivalence. And I do find that this application will provide substantially equivalent protections for public health, safety, welfare, environment, and wildlife resources. And I think probably the easiest way to discuss this is going through 604B4 and the subpoints within that to explain why. First is the director's recommendation. And as you can see here, the director has recommended that this be approved. Staff has worked with PDC and gone through numerous iterations of this, including going back and saying the initially proposed site we think should be done so you can consolidate here. And the fact that we've gotten to an approval there, I think, is important. B talks about the extent to which the oil and gas location design and BMPs will avoid, minimize, and mitigate adverse impacts. And here, I think that's absolutely happening. I think when you talk about avoiding adverse impacts, you're not having an additional surface location. You're consolidating the infrastructure here, so you're reducing it in that sense. We're talking about BMPs that are going to go into place to make sure that we're going to be electrifying the facility to reduce emissions. They're going through and making sure that they've committed today to using the e-fleet for the fracking system. And so you're taking these steps, you're taking these BMPs to make sure that everything is being avoided, minimized, and mitigated with that. And even when you look at the subpoints there, the anticipated size, duration, and intensity of the phases. And I think, again, this goes back to talking about that RBU owner. We're trying to make sure that this is not going to be a long drawn out process. And I think PDC, based on their testimony today and their application, has shown that they're going in and trying to say, we're going to go in once. As soon as we're done drilling, we're immediately going to bring the fracking crew in so we can do the completions, we can get in, we can get out as quickly as possible. So this is not being dragged out, in part because of, that's part of substantial equivalence, but also in part because that's what the landowners are saying is important to them. C talks about the local government's considerations. And as we heard from Mr. Maxey today, I think that Weld County has obviously gone through their in-depth process and found that this is an appropriate application for approval. D talks about the alternative location analysis. And to me, I think this was a big part of why I think this should be approved. When you look at the fact that this wasn't even the first site that PDC wanted to use, they wanted to use an additional site, but based off of COGCC staff wanting to say, hey, what steps can we use to go away from what you initially preferred to make sure we are taking the steps to protect public health, safety, welfare, environment, and wildlife resources. And one of the things that was done was going away from their proposed site, even though they had informed consent at those locations, and said, let's move further away from some RVUs. Yes, there is still an RVU within 1,000 feet, but now we don't have 4 RVUs within 500 feet. And we're taking steps to consolidate surface disturbance. We're taking steps to consolidate infrastructure, and taking steps to make sure that, and it's not even something that is unique in their operations. As Mr. Cocchiere testified, they have other well pads that have this many wells on them as well. So we know it is feasible. We know that this is something that's going to minimize disturbance. And I think that is an important aspect of this. They even also went through other locations where, despite trying, and not just saying we couldn't get a surface use agreement with these landowners, they went through the details as why. This was going to be right in the middle of a pivot point for agriculture. They were not willing to do it anywhere on their location. And when you go through those kind of details, I think it says a lot about the analysis that's done for that ALA. Part E talks about the related oil and gas location siting and infrastructure proposed. And again, I think having this being a combined location with everything else, you're obviously getting not only their new infrastructure and facility design, but you're also getting a consolidated infrastructure design here. And so all the oil and gas takeaway, all the produced water takeaway is all going off from a single spot instead of having to have pipelines going into 2 different areas within a close area. F is talking about oil and gas facilities associated that are designed to avoid, minimize, mitigate. Again, this is being consolidated, and they're taking steps with their new facilities to make sure that this is going to have the least emissions possible. And even again today, they've agreed and committed to using the E-fleet. And then finally, the operator's actual and planned engagement with nearby residents and businesses to consult with it. And here again, I think seeing the multiple pages, the numerous visits with the nearby RBUs to say, what can we do to make this easier on you? Taking steps to make sure that they're using the sound walls, taking steps to make sure that they're even beyond the operations, working with landowners to get the berms that they want, to get the fencing that they want, to understand and appreciate what their concerns are and working with that. And because of that, I do find that they do provide substantially equivalent protections. And overall, you know, I think this is one of those interesting scenarios where, with this being kind of the last part of a development in an area for them, we're going to run into some issues. And so kind of the alternatives of saying, do we have something consolidated? Do we not? A 54 well pad obviously has its concerns. And I know in talking to staff, they have some concerns with that as well, but you are getting the benefits of less disturbance. And in this commissioner's opinion, I think having that consolidation where the operator is showing that they can operate safely and efficiently from a pad and facility of that size already is going to have more benefits than trying to do a separate location with a smaller pad, because of less pipelines, less produced water takeaways, and everything else like that. So again, I'm appreciative not just of the applicant for their testimony today, for their work putting this together, but also for staff and working on this, because I know that this has also been going through the works for a while as well. So thank you to the staff for their hard work.
Thank you, Commissioner Cross. Commissioner Messner.
Thank you, Mr. Chair. Thank you for your thoughts, Commissioner Cross. I do think that this application needs to be, I mean, the primary way that we're reviewing this application is whether or not it meets the standard in 604B4. It is a little frustrating for me to see that not addressed in a standalone document, or not addressed in the presentation or the application clearly. The way that you went through it, Commissioner Cross, is the way an applicant needs to be able to address 604B4. This is the standard that needs to be met, and it is not limited to just the elements in there, but it is inclusive of all of the elements in 604B4. And so, you know, as I'm reading this application, I was really struggling whether or not this actually met those standards, because it is not this commission's responsibility. It's not our burden to determine, to make a showing of whether or not 604B4 is made. It's the applicant's burden and responsibility to make a showing. And so while I appreciate Commissioner Cross, you going through and essentially creating the showing for them, that's not this commission's responsibility. And so I think generally it's also an expectation. I would hope that it would be an expectation from staff that in reviewing an application for 604B4, that be a significant part of the analysis within the director's recommendation as well. I do note, however, that Ms. Trask did ask for a specific standalone document clearly identifying and addressing 604B4 and have that attached to the application, which the applicant did not do, and it was not further called out within the director's recommendation. And so I will start out by being a little prickly with that, because that to me, an operator with this level of experience, that should be first and foremost what it's addressed in the application. Now, having said that, I do think that working through the application in the commission hearing right now did allow me to find the information I needed in order to be able to show, to have a finding to make of substantial equivalency based on Rule 604B4. And these are some of the things that I think are important, which will be some of the things that are similar to what Commissioner Cross indicated. But the retrofit of the existing facility, utilizing an existing facility is one thing, and I think that that's good. This one like pushes the envelope of that a little bit, because I think that while we're utilizing an existing facility, there's also RBUs or sensitive receptors that are associated with that. And so, you know, I looked pretty closely at the ALA and the analysis within the ALA to determine whether this truly was the most protective site and whether it met our rules or not. However, understanding that there was 12 uncompleted wells associated with this, and that there was additional wells that were on this pad that could be retrofitted to be both tankless and also to be electrified in their productions as part of this overall package, was compelling to me as far as determining substantial equivalency. And really, these initial operations are pre SB 19-181. They're being retrofitted to be post SB 19-181, and the associated reduction in emissions, in noise, is significant, and reduction in truck trips. I think that the determination to ultimately utilize the E-fleet was really important to me as well. And the in order to meet some of the standards in 604B4, particularly 604B4 B and 604B4 F. And so those two elements, the opportunity to complete 12 wells that were previously approved before SB 19-181 utilizing SB 19-181 standards, as well as moving through the additionally approved ones, is a significant reduction in net adverse impact from this commissioner's standpoint. I do appreciate that there has been communication with the RBU owners. It's clear to me that there's going to have to be continued and robust interactions with the RBU owners, as this is going to be a significant build out. Although all being done in one fell swoop, I think is also an important piece, and I think also helps with the substantial equivalency standard. And the last thing I'll mention is that I do think it's important for accuracy now that this this application may be moving forward with different BMPs to update the cumulative impacts report to ensure that we actually have the clear and accurate information associated with that. I'll also mention that I think the air monitoring program is also a good piece of this, especially understanding that there is experience and knowledge around monitoring facilities of this size, and no clear history of issues associated with emissions because of that. And so I overall see this as really a reduction in overall emissions, even with new operations, a reduction in overall noise because of new technologies, a reduction in overall facility size, and amount of tanks on site because of the retrofits and upgrading of facilities as part of this. And so that, to me, ultimately changed my decision. But I'll be honest, coming in today without this discussion today, I did not find that the application provided enough information for me to make a determination of substantial equivalency. And I'm sure it made that finding or that standard. So those are my deliberative thoughts, and I'll be done.
Great. Thank you, Commissioner Messner. Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that. Starting with the discussion surrounding the electrification of drill and frac rigs, this is a very important issue to reducing emissions and reducing ozone precursors associated with oil and gas development. That's really very visible, and I think is a very important approach to help meet the governor's direction, even ahead of reducing on-site emissions through retrofitting outdated equipment. Again, very important, very visible. But I would note that the proposal as presented to us falls within existing regulations. An argument could be made that it bumps up a bit against CDPHE consultation regs in 309F, but it is nonetheless a consultation as required, resulting in implementation of BMPs as required, and in my opinion is therefore in compliance with our regulation absent CDPHE recommending denial on this specific basis. I do very much appreciate PDC's commitment to move to all electric rigs within the next 18 months, and once again encourage them to take a holistic approach to ensure the success of that goal. I also feel that this is in compliance with wildlife rules. I appreciate the significant work that went into ensuring that it is. I agree with CPW that I would expect bald eagle nesting and roosting to continue in the area, as the area is generally of high quality for raptors. I appreciate the operators' substantial monitoring and their commitment to continue monitoring and coordinating with CPW on bald eagles, as well as the other wildlife BMPs that are included in the application, which are numerous, but that we haven't highlighted here today. I also agree with the ALA determination, and I appreciate the careful consideration and deliberative process given to that process. So as with the other commissioners, the substantial equivalency question is the issue at hand for me. And I appreciate Commissioner Cross, as I had also prepared to talk about those in detail. And I also agree with and reiterate the point made by Commissioner Messner on directly addressing what to me was the most glaring potential point of regulatory non-compliance in this application. Again, I think I agree with all of the points that were made by Commissioner Cross and Commissioner Messner. And without going through the specifics of substantial equivalency, as Commissioner Cross has already done that, I also wanted to recognize that I was also on the bubble on this application, and came in with pretty significant concerns about this specific issue. I do recognize that PDC has historically and within this development committed to practices that are over and above those required by our regulations, and this shouldn't be overlooked. I appreciate PDC's clear commitment to work with affected landowners, as they've done in this case and in every other case that I've seen, and especially ask you to continue to work with the occupant of the RBU1 with regard to this application should it move forward. And again, I was also impacted by the commitment to an e-fleet on site. I appreciate you being nimble and working hard to make that happen. I had similar thoughts to Commissioner Messner about pad workover, going tankless, electrification, all strong benefits. And the point that really compels me in this particular case is that the operator already has a permit and plans to complete 12 other wells on this site. The site's going to be reoccupied regardless of our decision on this, likely reoccupied regardless of our decision on this OGDP. And I do appreciate and recognize that PDC responsibly decided to wait for this process in order to not have an additional third occupation of the site should it be approved. I wanted to once again recognize and appreciate PDC's commitment to not incorporate DUC wells or kind of a lick the stamp approach on second occupations into its regular standard business practices going forward. And I certainly will keep an eye out for those potential situations in the future. So that said, I think that through the discussion today and through the points that were made by my fellow commissioners and by PDC, I can be supportive of this application as it's proposed.
Thank you, Commissioner Ackerman. Commissioner McGowan.
Thank you, Mr. Chair. I don't know if I'm still echoing, so if I should just try to be brief. I am. So I don't have too much to add other than the substantial equivalency and what was happening to those folks who were within 2,000 feet was the focus for me, obviously. I do think that there are benefits to this proposal that I appreciate. So even though we're adding wells, we will see a reduction in long-term emissions, which I think is better for the folks who are already living near those existing wells by going tankless, electrifying their site. I do want to add that for me, electrification of the drill rig is important, but I also know that there are other strategies that reduce emissions, and that's dual fuel, battery combinations. And so just for heads up, if there's a situation where you can't use electric, to not just explain why you can't use electric, but why the other alternatives are not available. And it was helpful for me to have the discussion today about that. I do appreciate the commitment to the e-fleet for completions. My concern was the upfront emissions where we see the most and trying to figure out how we can reduce that to combine with the benefits on the back end to reduce those emissions in this proposal. I do think it was important to note that regardless, even if we had said no to this, there were existing wells that the operator could come back and drill anyway. So coming back for a single occupancy in and out was another consideration for me. I also want to commend the operator for their informed consent form. I read it, and for the first time, compared to some other operators, it didn't feel legalese. It didn't feel like folks felt like they were signing anything away. It was easy to understand, and I felt that the person who signed the non-consent form would have a clear understanding and pathway to know how to participate in our process if they actually opposed what was happening versus they understand that this is going to happen and they're not really happy about the inconvenience it's going to cause them, and that's understandable. I think a lot of folks think if you come in and drill, then you're done, and they don't want to see you come back. And to Commissioner Ackerman's point, that is the strategy we all prefer to see in the future. Folks don't want you coming back in, they think you're done. And it is pretty disturbing. So those are kind of my big thoughts. I think also this is not the first time where we've had a conflict between our rules, where we're encouraging operators to consolidate their development and use existing locations. And sometimes that bumps up against where people are and our 604 B series, and having to figure out how we balance those out, and having operators really bring robust information to help us figure those pieces out. So I will echo my fellow commissioners, the substantial equivalency piece would have been better and easier for us to go through if we had more upfront information. But I agree this is an approvable.
Let's see, I'm unmuted. Thank you, Commissioner McGowan. I'm in agreement with my commissioners. I would note to this operator and all operators that if you're pursuing substantial equivalence approval, do run through the actual rule, like Commissioner Cross did. I'm in agreement with the way Commissioner Cross did it, but I think it would be helpful for you to just acknowledge that. I am appreciative of the support from Weld County. I'm appreciative of the BMPs. I'm appreciative of the consolidation. I also, just from this commissioner's perspective, would note that 604B4, the substantial equivalence approach, is the rule that was crafted when informed consent is not obtained. And so the concept that we need to have informed consent from everybody, or somehow or another that makes substantial equivalence unworkable, I think in my mind that's mixing two different rules. In other words, if the operator can't get informed consent, then there is this other avenue. So I did not get hung up, at least this commissioner did not get hung up with the fact that a couple of the residential building units did not provide informed consent. I think that just logically means the operator needs to go a different route. Obviously, we're all in agreement that it's better if informed consent can be obtained, but that rule does exist for a reason. And I think in this instance today, this is approvable under that rule. And with that, unless there are further deliberative thoughts, I would look for a motion. Commissioner Cross.
Thank you, Mr. Chair. I would move for approval of the application with the condition of approval discussed today to use the e-fleet for completions.
I'll second.
AAG Mercer, thanks for visualizing. Did you have anything?
Thank you, Mr. Chair. I just wanted to clarify Commissioner Cross's motion, because in addition to the e-fleets, I and staff tracked, I believe, 2 other commitments by the operator that I wanted to see what intended to include those in your motion. And those were committing to a single occupation for all of the wells proposed in this application, as well as the other permitted but not yet completed wells at the location, and submitting updated emissions information on an updated Form 2B.
Commissioner Cross, do you agree to the friendly amendment to your motion?
I would absolutely agree to that amendment.
And okay, so that now we have a motion. Do we have a second?
Second.
Okay, second from Commissioner Ackerman. Mr. Prishala, there's a motion on the table with a second. Before we move into acting on it, does the 3 conditions of approval ring true to your client?
Yes, they do.
Thank you. Further deliberation on the pending motion. Seeing no further deliberation, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Prishala, to you and to your panel. Appreciate the work there. Thank you to our staff as well for the good work it did. Appreciate having Doug Andrews on board today to be able to provide that additional information. So with that, I believe we have exhausted the parts of our agenda. We have nothing left other than for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. Thank you, everybody.